Hey,
Hey,
Hey, good afternoon, everybody. Sorry,
hey,
excuse
sis,
my
what's up
voice.
with it? What's up? What's up with it? I want to
Hey,
get my
Paige.
intake. I want to get my input on this.
No, that's
okay.
right, Paige.
Girl, I've been following
Welcome
this
to the
stuff for
panel,
3 days.
baby. Welcome to the panel.
I've been
Yes,
following this
ma'am.
for 3 days. I know I was the one in the comments yesterday writing
Yes,
paragraphs. Man,
I
this case
already
got me
know.
so mad.
yes. Welcome, welcome.
Yes, we
I
gonna
believe Susan
go ahead.
shot AJ on purpose. She did it on purpose, y'all.
You sure
hmm
did.
She
Absolutely.
did. And when you go in that house, I was thinking that the house was like a efficiency. You know, like how you had a bathroom in the
hmm
bedroom. You know,
hmm
that one room.
Oh, a
But
master
when y'all
bedroom
was,
type. Okay.
yeah, when they were breaking it down in the 3D thing, and I wanted to
hmm
see where the window was at, but it's a wall behind that TV. You feel what I'm
hmm
saying? So
hmm
she had to been standing in the kitchen and walked up a little bit in the living room and shot that thing. Cause she shot her in the rib or the
Boom.
chest. Which one was it?
We don't
The
want to.
chest,
We
I
don't want to
think.
say that word too much because they'll flag my video.
Oh,
So
yeah,
say
let's
Okay, all
say.
right. So we
fire,
gotta find
Let's just
fire.
say
slide.
hit. She hit her or
She
whatever.
hit
Yeah,
her. Yeah, she
Yeah.
yeah,
can we say that?
yeah. You
Yes.
can. Just don't say
Okay,
the SHOT.
okay. I was like this right here. I was like, if that older woman, I believe
hmm
she been to the shooting range. I mean the shot. I mean the slide range. I believe she
hmm
been to the range.
Mm-hmm.
I believe she
Actually said
said that
in interrogation. Yeah.
hmm
yeah, but I think she had it longer than what she purchased. But they said
But
she purchased one
hmm
recently before the
hmm
incident.
hmm
I believe she had been doing some stuff,
but
like
remember, I meant to mention this yesterday during her interrogation. One of the detectives asked her when he said, "Are you up? Have you been to like the range? Have you took some training and using a firearm?" She said no, and she also mentioned that she thought of taking the written test for the permit. So she was carrying without a permit, without a license to carry. So in Florida, I wanted to ask y'all. So in Florida, they can just carry. They don't need to sign no paperwork. They don't need to get practice. They don't need none of
It's
that.
it's certain type of weapons you can have without a license.
Oh,
I
okay. It's like
know
going to Walmart. You can just buy a firearm.
would stand your ground being legal, being a law in Florida. I'm not sure they laws they might be a little bit different,
hmm
but it's certain weapons you don't have to have a permit, and I think it's like the
Oh, okay.
shotgun.
okay. The
Or
saddest
Okay.
thing, the
That's what's
saddest
cute.
thing, the
hmm
saddest thing I found out about this case is when they was interviewing them children. You
that
remember
hurt.
the little Mexican little boy?
Yeah.
Hmm.
Now that brought tears to my eyes, and that cop said, "Is the daddy ever around?" You
Oh.
know, the way they look at us, like y'all
hmm
broke this case down all the way to the nibbles and the cribbles. You hear me? I promise you, because I didn't pay attention to the interviews with the cops, and
hmm
they sounded
Best
so
part.
That's
biased.
why we do this.
That's the best part.
That's
Well,
Breaking
y'all
that's
it
got
down.
some
why we
people on the
do
other
it.
end. Y'all got some people on the other end paying attention like that for real. Cause
Yes.
without y'all, I wouldn't have known all this stuff about this case. You
Well,
feel?
hmm
listen, thank you so much.
Thank you.
I'm
Right.
actually happy that you came up. Paige has been up here with me before, but we're
Mm.
gonna get into it and we're gonna talk
Yeah.
about
Stay
it
with us,
afterwards.
Paige. Don't leave.
Yeah, hang
Okay, let's
out
go.
as long as you can, and we gonna go straight through with this.
Okay. I'm
Okay.
gonna mute.
Me
Okay, and
too.
I'm a
Me
mute
too.
too. All right, perfect. Y'all good in the chat? Y'all got the popcorn because it's looking good, y'all. He did really well. I already watched it. And there were some things that he left out. We'll talk about it later. Let's get into it.
Intentionally fired it. There's no doubt the defendant intentionally committed an act which caused the death of Ajike Owens. And we also know that Ms. Owens died as a result of that gunshot wound. The state's proven this beyond any reasonable doubt. You heard the judge read an instruction. You may be back there thinking, well, what if the defendant didn't intend to kill Ms. Owens? Well, the judge has told you that that is not an element, that's not a requirement for the state to prove in a manslaughter charge that the defendant intended to kill Ms. Owens. She's not charged with first-degree premeditated murder, which would require an intent to kill. She's charged with manslaughter. The judge told you that in order to convict of manslaughter, it's not necessary for the state to prove the defendant had an intent to cause the death. we'll get into what the state only has to show that the act was not merely negligent, justified, or excusable. And we're going to get to those terms in a few minutes. Because element A of part A of element 2 has been proven beyond any reasonable doubt, there's no even need to get to B. However, the evidence has also proven that the death of Ajike Owens was also caused by the culpable negligence of the defendant. The judge read to you a long instruction about culpable negligence, told you that each of us has a duty to act reasonably towards others. In order for negligence to be culpable, it must be gross and flagrant. It has to show a reckless disregard for human life or the safety of people exposed to its dangerous effects. It has to be committed with an utter disregard for the safety of others. The evidence has proven that the defendant did act with utter disregard for the life of others. She pointed a loaded firearm towards a door, towards a person that she knew was there on the opposite side of the door, and intentionally pulled the trigger. That shows a reckless disregard for human life. It's an act which she must have known or reasonably known would cause death or serious bodily injury if that projectile struck somebody. The evidence has proven beyond any reasonable doubt that the act of firing that gun constitutes culpable negligence. The crime of manslaughter has been proven beyond any doubt whatsoever, ladies and gentlemen. The question in this case lies with whether or not she was allowed to shoot and kill Miss Owens under these circumstances. The law says that in certain circumstances, a person cannot be held liable or responsible for shooting another person. And the first situation is if the killing was excusable. The judge read you this instruction a few minutes ago. I'm not going to read the whole thing, but in order for a killing to be excusable, the killing in each of those three situations has to be committed by accident. And we've already discussed that this was not an accidental discharge. It's not a situation where she was playing with the gun and it accidentally went off and shot through the door, or she dropped it. This was an intentional act. So excusable homicide is not relevant in this case. Another way in which a person could not be held legally responsible for killing another is if the killing was justifiable. You heard Judge Hodges read a few minutes ago that the killing of a human being is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant or commit a felony in any dwelling house in which the defendant, was at the time of the killing. That is the general instruction on justifiable homicide. The judge read to you a longer, more detailed instruction, which is what I'm going to go over now. Judge Hodges explained to you that if the defendant was in a dwelling or residence in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent either A, imminent death or great bodily harm to herself, or the imminent commission of a burglary, murder, or aggravated battery against herself. That first sentence there, if she was in a dwelling or residence in which she had the right to be, she had no duty to retreat. That applies in this case, ladies and gentlemen. The defendant was in her own home. The law accounts for that because people do have a right to be in their own home and be safe in their own home. That applies in this case. The law does not require her to jump out the back window and retreat in order to avoid this because she is in her own home. She doesn't have to do that in order to claim that she acted in self-defense. Now, her actions inside of her house and what she does during this period of time is relevant to look at the reasonableness of her fear and the reasonableness of her actions and decision in making and shooting. But she is not required to try to jump out a window to avoid this before she can claim self-defense. The crux of this case, ladies and gentlemen, is whether at the time she fired her gun at that closed, locked, deadbolted door, did she reasonably believe that her conduct was necessary to prevent imminent death or great bodily harm against her, or the imminent commission of burglary, murder, or aggravated battery. The instructions that the judge read to you gives you an explanation of what burglary, murder, or aggravated battery mean legally. And I'm going to go through those later on. He read them to you, so I'm not going to go over them again right now, but we're going to address those later on. The judge also explained to you that in deciding whether the defendant was justified in using deadly force in firing that gun, you have to consider the circumstances under which she was surrounded at the time she chose to fire. Judge Hodges explained to you that the danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real the defendant actually believed the use of deadly force was necessary. Well, what does it mean by the danger need not be actual? Well, if the bailiff here and I are getting into an argument and I start getting heated and I start walking towards her and I pull out a gun and she pulls out a gun and shoots and kills me, but my gun was a fake gun, my danger to her wasn't actual. But all the circumstances surrounding it made her think that it was. So the actual danger need not be actual, but the defendant actually had to reasonably believe that the use of deadly force was necessary to prevent an imminent harm to herself. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. The standard by which you review this is based on whether a reasonably cautious and prudent person under the same circumstances the defendant would have felt the danger was necessary. You take a normal, average, everyday person and ask yourself, would that normal, average, everyday person under these circumstances have believed that it was necessary to use deadly force to prevent the imminent harm to themselves or the imminent commission of a burglary, murder, or aggravated battery? I've used the word imminent many times because that's in all of these definitions, and that's very important. It's not that something bad could happen in the future or something may have. That something bad has to be imminent, immediate, about to happen. So let's start with whether or not the defendant reasonably believed that her firing the gun was necessary to prevent imminent death or great bodily harm to herself. What were the circumstances she found herself in at the time she chose to pull that trigger? Because that's the relevant time. When she makes that decision to pull that trigger, what are the circumstances surrounding her? That's what the law focuses on. Taking a step back, though, we know that there have been past issues between the defendant and Ms. Owens. We've heard about a couple issues during the testimony and the evidence that they had some conflicts in the past. That information is relevant to you, could be relevant to you to consider, because those past contacts between the defendant and Ms. Owens could factor into the reasonableness of her decision in pulling the trigger. They may not. But the judge read to you, if you find a defendant who, because of threats or prior difficulties with Ms. Owens, had reasonable grounds to believe she was in danger of death or great bodily harm at the hands of Ms. Owens, you may consider this fact in determining whether the defendant's actions were those of a reasonable person. I want to talk a little bit about those prior issues. We know that these prior run-ins were the result of the defendant acting out or doing something towards the victim's children, Isaac and Israel. And at the time, we heard that Isaac was about 12 years old, Israel was about 9 or 10 years old. We heard that the defendant complained about the children, complained about them playing in this field, this open lot next door to her house. You heard that these children would play in that open field. They played football, they played some bottle game and some running around, what kids do. They weren't breaking into cars, they weren't vandalizing.
So ruled. Go ahead.
They weren't causing problems, vandalizing things, they were playing. And you heard from Frank Colon, who told you he was often out there playing with the children regularly to make sure they behaved. But as children do when they're playing, especially in groups, the children got loud. The children yelled and screamed and played to do what kids do. The defendant, the evidence has shown, didn't like that. She told the detectives in the interview she worked from home. The loud noises interfered with that ability. She didn't like it. She complained to Charles Gabbard, her landlord, and Charles Gabbard, in response, in order to pacify her and appease her, got some no trespassing signs, those little signs that you get from Lowe's or Home Depot, and put them in the ground. She complained to the police about the children when she would call, complaining that the children were too close to her property or trespassing on her property or leaving things on her property, toys, and that they were loud. It's important to note that Charles Gabbard owns the property the defendant lived in, but he does not own that open field where the children played. Charles Gabbard has no ability to tell those children don't play there or tell the children to be quiet, and neither do the police. You heard on two prior occasions that there were some prior difficulties between the defendant and Ms. Owens. You heard on one occasion, which happened February 25th of 2022, about 16 months prior to the shooting, that the defendant was again upset about the children playing, being loud, doing what they were doing. And you heard from London Remy, the 13-year-old girl that testified on the first day of this trial, that Ms. Owens walked over to the defendant's area, and there was an argument between the defendant and Ms. Owens. Ms. Owens went over there to tell the defendant to stop yelling and treating her kids the way that she was. There was an argument, and Ms. Owens pulled the no trespassing sign out and tossed it at the defendant as she was walking away. You heard London Remy talk to you about that. And she explained and even demonstrated how Ms. Owens took the sign and tossed it as she was walking away. And that sign hit the defendant in the leg. Was that the proper way of probably handling the situation by Ms. Owens? Probably not. But what's important to know is there were no punches thrown. Ms. Owens didn't run up and attack the defendant, didn't punch her in the head, knock her down, kick her, didn't, bust into her house or anything like that. Ms. Owens said what she had to say, tossed the sign, and walked away, leaving the confrontation. The defendant called 911, the emergency line. The officers came out, talked to everybody, and no arrests were made. On another occasion, December 22nd of 2022, about 6 months before this crime, the defendant was again angry at the children for being loud. Obviously, the children told their mother because, again, Ms. Owens came over to the defendant's property and told the defendant not to yell at the children. We heard from Deputy Kinsey, who spoke with Ms. Owens, and Ms. Owens told Deputy Kinsey, I walked over there with my child and wanted to talk to the defendant and deal with the situation. According to the defendant, the victim told her that if you yell at my kids again, I'm going to drag you out and beat your butt, basically. But remember in the defendant's second interview that you heard with the detectives, she was specifically asked if she remembered any kind of threats like that. And the defendant said she didn't remember anything. So either Ms. Owens never made such a statement or the statement wasn't so significant such that the defendant even remembered it to talk to the detectives about it when specifically asked. And we also know that the defendant, moving ahead to the night of the shooting, the defendant tells the detectives that Ms. Owens came over and said, I'm going to effing kill you over and over again. No one else heard that. You heard from Jared Gardner, you heard from Ariel Rodriguez, who were right there. They said she never said that. So back to February of 2023. We know that Ms. Owens was upset about how the defendant was talking or treating her children. Ms. Owens walks over to the defendant's property. They have this argument, disagreement, whatever you want to call it. There's no violence. There's no punches thrown. Ms. Owens doesn't knock the defendant down and kick her and beat her. She doesn't try to break into her house, shatter her sliding glass door to get to her, nothing. It's a verbal argument, and the verbal argument ends when Ms. Owens walks away from the situation and goes back to her house. The defendant again calls 911. The police come out. They interview everybody. No arrests are made. As I said earlier, you can consider these prior difficulties between the two in determining whether or not they contributed to the defendant's decision to fire that gun that night on June 2nd, 2023. I submit to you that these two episodes, one of which happened about 16 months before the shooting, one happened about 6 months or so before the shooting, involved no violence except for the tossing of a sign, a flimsy Lowe's no trespassing sign. They didn't involve the defendant or the victim trying to break into the defendant's house. didn't involve Ms. Owens beating the defendant up or causing her any physical injuries, and were resolved when Ms. Owens walked away from the confrontation. Now, it's interesting in her interview, in the defendant's interview, that she described an incident that happened about 2 months before the shooting on June 2nd, after the sign throwing incident, after the second incident that happened in December of 2022. She described an incident that happened about 2 months before the shooting. Now, the defendant in her interview tried to explain how this sign throwing incident and this other incident caused her such terror of Ms. Owens, such fear, such panic, because Ms. Owens was so violent that contributed to her, the reasonableness and why she decided to fire the gun. But let's talk about what the defendant said in her interview about the incident that happened 2 months prior to the shooting, after these other things. She's talking to the detectives about the sign throwing, or about this incident that happened 2 months before, and she tells the detectives, and one time she was talking to the neighbors, meaning the defendant, or meaning Miss Owens, and she said, "Oh, that bitch over there is crazy, you know? I'm not going, sorry. I walked over. I said, what is your problem?" And she just went on a tirade. She tells the detective, "I walked over and said, what is your problem?" The defendant admitted that she was the one that walked over and confronted Miss Owens about Miss Owens telling a neighbor that the defendant was a crazy bitch. And she told the detectives further that she was actually over by Miss Owens's driveway when she confronted Miss Owens. Does that sound like the actions of someone who was so terrified because somebody tossed in a trespassing sign and someone came over and had an argument with her earlier? Does that sound like somebody who's so afraid of this woman that she's going to walk up to this woman, confront her in her own driveway? Or does that sound like someone who is angry at Miss Owens and has no problem initiating confrontation? The defendant also explained that during this same incident, two months or so before the shooting, that Miss Owens accused her, the defendant, of using racial slurs towards her children. The defendant during an interview explained, "Look, I told her I didn't do that. She kept insisting I did." And the defendant said, "I eventually just said, I'm sorry," to diffuse the situation. There is probably nothing more infuriating to an African-American woman.
So overruled.
There is probably nothing more infuriating to an African-American woman for someone to believe that someone used a racial slur towards her children. But what does Miss Owens do when she thinks this is what happened? She doesn't go over and attack the defendant, she doesn't go over and beat the defendant up. She doesn't go and attack Miss Lorincz, push her down, say, "This is what you told my children." She goes and she has an argument. And Miss Owens doesn't resort to violence. Miss Owens walks away. Miss Owens, if she wanted to, had every ability to attack the defendant for that. But she didn't. She had every ability because even then, there wasn't a closed, locked, deadbolted metal door between them. Despite not having that barrier, Miss Owens did not do anything violent towards the defendant. Instead, she walked away without incident. Which brings us to June 2nd, 2023, the day of the shooting. We saw videos taken from the defendant's cell phone during the couple hours before the shooting happened. They showed the children playing in that open field. You saw Frank Cologne out with the children one time in one of those videos. And in one of those videos, taken at 8:49:51, we see Israel waving past the trespassing signs on her property, waving at her. Once again, the defendant was angry because the children were being loud and it was bothering her. And Israel went past the no trespassing sign. And you heard from Muriel Rodriguez, who said, yes, in fact, that night, Israel did go past the no trespassing sign. We saw that in the video we just looked at. We heard from the defendant's 911 call in the interview with the detectives that there was some altercation between the defendant and Miss Owens's children. It involved a tablet, roller skates being thrown, an umbrella being shaken, something. The facts of that altercation really aren't important or relevant. What's relevant is that that is the catalyst. That is what causes the children to go and tell Miss Owens. And that's what causes Miss Owens to come over and once again deal with an issue regarding the defendant and her children. We heard from the 911 call that the defendant made, the first 911 call before the shooting, and she acknowledged there was an issue with the children. She acknowledged that she threw some roller skates. She acknowledged and told the 911 operator that the child accused her of stealing the iPad. We heard in the 911 call that in the interview that there was something involving shaking an umbrella as well. So we know that the defendant got into some sort of argument or something with the children, which caused the children to go talk to Miss Owens, their mother, and causes Miss Owens to come over to deal with it. You heard from Jesse Newbanks, the Marion County Sheriff's Office digital forensic examiner who examined the defendant's cell phone. And going into the logs of the cell phone, we know that the defendant first made that first 911 call that we heard at 8:54:09 p.m. And you heard her on that call. That was played earlier. You heard her. She was angry about the children trespassing, angry about that 9-year-old stepping onto her property, angry about the children leaving things in her area. She was angry the kids were being noisy. And she admitted to throwing the roller skate like we saw in the photo a few minutes ago. She told the 911 operator that she was sick of the children. Her words were, "They are bothering me. They won't effing stop." She wasn't afraid. She was angry. You heard the tone of that 911 call. The 911 call, an operator asked, "Are you in danger?" And she said, "No, I locked my door." She locked her metal door. We know from her 911 call, the main lock was engaged. We know from her interview with the detectives, the deadbolt was engaged. So at this time, she is behind a closed, locked, deadbolted metal door, standard metal door, about 1 3/4 inches thick. She's behind that in her concrete block home. Now, let's take a pause from June 2nd. You heard some information about the door jamb having some prior damage to it. And we saw photos, the state introduced photos of that door jamb and the prior damage. We heard from the landlord, Charles Gabbard, who said, yes, that door about a couple months earlier had some damage to it. I went and repaired it. He told you he replaced the strike plate of the lock. He replaced the strike plate for the deadbolt. He drilled those things into the door frame and it was secure. He used some wood putty to further secure it. And the only thing that was left was some cosmetic damage that didn't affect the integrity or the stability or the durability of that door. He told you that when he left, the defendant was content with his repairs, except for the cosmetic damage, which he said, I'm going to come back and make it look pretty. But that door was secure. There was no concern at all that that door wasn't going to hold up if someone banged on it. So we talked about the first 911 call was made at 8:54:09 p.m. And based on Jesse Newbanks' analysis, that call lasted 4 minutes and 55 seconds, which means she hung that phone up at 8:59:04. At 9:01 and 37 seconds is when the data on her phone says she picked up the phone again to call 911 after the shooting happened. So whatever happened with Miss Owens coming to the door, banging on the door, the defendant going in to her bedroom, getting the gun, coming out, aiming at the door, shooting, and then her getting her cell phone and making a call took 2 minutes and 33 seconds. Not the 10 minutes like she told the detectives. 2 minutes and 33 seconds. So again, the evidence has shown that before she makes the second 911 call, Miss Owens walks from her house across the street to the defendant's house to deal with the situation involving her children. Witnesses said she walked over there with purpose. She was mad. No question. Jared Gardner told you that he heard Miss Owens say, after she's banged on the door, something to the effect of, "Come out here, bitch," or "Bitch, open the door," something to that effect. Jared Gardner told you he never heard Miss Owens say anything like, "I'm going to effing kill you. I'm going to break down your door. I'm going to go in your house." He didn't hear anything like that because those statements weren't made. He heard Miss Owens tell the defendant, "Come outside." You heard from Uriel Rodriguez, 12-year-old Uriel Rodriguez, the second witness we called. He told you he saw Miss Owens walk across the street, saw her walking with a purpose, saw that she was angry, it was clear how she was walking, saw she didn't have anything in her hands. He heard Miss Owens say, "Come out." And he said she used the B word and the F word, consistent with what Jared Gardner said. So he too hears Miss Owens say, "Come out, bitch." Uriel Rodriguez said he never heard Miss Owens threaten the defendant, say, "I'm going to F and kill you, I'm going to bust in your house," anything like that. It was "come out." Miss Owens made it clear to the defendant that she wanted the defendant to come out and deal with this situation. If Miss Owens wanted to get into that house, all she had to do was take something from the patio, one of that little Santa thing that was sitting there, throw it through the sliding glass door, shatter the door, and get in there. She didn't do any of that because her goal was not to get in the house. It was to get the defendant to come out and deal with the situation with her children. Even in the defendant's interview with the detectives, she was asked what was the first thing that came out of Miss Owens's mouth. And the defendant said, Miss Owens first said, "I want to speak to you because you're talking to my sons. I don't like the way you're talking to my sons." First thing out of her mouth deals with her sons. First thing out of her mouth is not, "I'm going to bust in your house and I'm going to kill you." It's, "I want to talk to you about my sons," just like the last times. You heard from Yvonne Costa, who's the neighbor who had the joining wall to the defendant's apartment. She told you that she heard arguing, loud arguing, and then she heard a door slam. Clearly, this was the defendant slamming her door after she was arguing with the children, because Yvonne Costa said a few minutes later is when she hears the pounding, and the pounding was loud. There's no doubt about that. It was loud enough to shake the wall between the two of them that they share, maybe even rattle a mirror. It was loud, but it wasn't banging hard enough to damage the door. There's no dents. There's no major problems with the door. No damage to the doorknob as if someone was trying to beat on it and break the doorknob off to get in there. She was banging hard like law enforcement officers do when they come to a door and say, "Marion County Sheriff's Office." And in fact, the defendant actually told the detective she initially thought it might be the law enforcement coming. Why? Because she just called them and knew they were coming. She knew they were coming before she fired the shot. Everyone then, after the banging, hears the shot. You heard the interviews the defendant gave and the 911 calls. The defendant never said that Miss Owens was rattling her doorknob, shaking the doorknob as if she was trying to get in. She was specifically asked during the second interview, did she ever try to open that sliding glass door or open the door handle or anything like that? Or was it just pounding? The defendant's answer was, "I just remember her pounding and pounding." You also heard in the interview that the defendant gave that the sliding glass door was further secured by a wooden stick in the track, so the door couldn't be opened. It was locked, the door couldn't be opened because of that wooden stick. The defendant never told the detectives during the interviews that Miss Owens was trying to open that sliding glass door, that she was banging or jiggling on the doorknob trying to get in. Never told them that she was trying to break her window or anything like that. Rather than wait for law enforcement to arrive, because she knew they were coming, because she called and they told her that law enforcement was coming, she went into her bedroom and grabbed her gun. She doesn't grab her phone, which she just had in her hand 2 minutes earlier, to call 911 again. She goes in the bedroom and grabs her gun. She goes back into the family room. She approaches the door to the point where she says she reached that kitchen table. She doesn't fire a warning shot through the door or in the air, into the ground, anything like that. We heard her in her first interview say she never intended to kill Miss Owens. Well, look at the placement of the shot that she fired. She took aim. She leveled the gun at the door. She aimed directly where a person would be if the person was knocking on the door, at a height consistent with where Miss Owens would be, and pulled the trigger. She didn't fire over and over and over again. She didn't unload her magazine as if she was in a panic. She fired one controlled, precise round into the door at the exact place a person would be if they were knocking. Then she had the presence of mind to go back into her bedroom, put that .380 Remington back in the trash can, underneath the .22 caliber Ruger that was found. Because remember, CSI Medina found the .380 gun, the gun that used to fire the bullet in this case, beneath the .22 caliber Ruger, the little plinker. And then she has the presence to call 911. So now that we know what the evidence has shown, let's go back to the instructions that we looked at earlier. The circumstances that she found herself in when she fired that round were that she was angry at Miss Owens' children, such that she called 911 on the children. That an angry mother was banging on her door, yelling at her to come outside. That she is behind a closed, locked, deadbolted metal door, and she knows law enforcement is on the way. She goes into her bedroom, she grabs her gun, walks back to the living room, walks towards the door, fires one precise round in the exact location where a person would be. Those are the circumstances by which she was surrounded when she made that decision to pull the trigger, at the time she decided to use deadly force. There was no imminent danger whatsoever when she fired that gun. Miss Owens had not broken down the door. She hadn't gained access to her house. She hadn't shattered the sliding glass door to get in. Miss Owens was banging on the door, telling the defendant to come out. A belief that there was an immediate or imminent danger such that deadly force was necessary at that time was simply unreasonable, because there was no imminent danger. And that word imminent is very important. It's included in the law for a reason. In order for the defendant to be allowed to use deadly force, that threat to her life must be imminent. It had to be ready to happen. It had to be staring her in the face, such as she had to act at that moment to protect her life. If Miss Owens would somehow have managed to bust through this locked, deadbolted metal door, entered her house, and started coming at her, the defendant may have had a right to shoot, because that danger would have been imminent. But that's not the situation we have here. We talked about Part A, imminent death or great bodily harm to herself. She would also have the right to use deadly force if she needed to do so to prevent the imminent commission of a burglary, murder, or aggravated battery against herself. Murder is defined as the intentional, unlawful killing of another by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Again, there's no evidence to support that at the time the defendant fired that gun, that Miss Owens was...
My bad, interrupting Ms. V. Could you pause a second?
No ability whatsoever to get into that house, to even try to cause her harm. There is the secure, locked.
Paige says she's backstage trying to get in.
It's not a situation where Miss Owens was charging at the defendant with a gun, a bat, a knife, something like that.
Flick your camera, Paige. I had walked away, y'all.
That's not our situation.
Oh, that's all right.
Okay.
Similarly, the crime of aggravated battery is an intentionally touching or striking another with a deadly weapon, or intentionally or knowingly causing great bodily harm, permanent disability, or permanent disfigurement. Just like the previous explanation, Miss Owens, at the time she was shot, had no ability whatsoever to even get into that house. It also is interesting to know that at no time during the interview does she claim to think that Miss Owens had any kind of a weapon. There's no evidence to support that Miss Owens was in the process of committing an aggravated battery or about to cause her imminent, immediate harm when she fired that gun. Let's talk about burglary. The defendant would be allowed to use deadly force to prevent the imminent commission of a burglary upon herself. Well, what is burglary? Burglary is entering a structure owned by or in the possession of another with the intent to commit a crime therein. And the crime can't be burglary or trespass. The judge also read you the definition of structure. It means any building of any kind, temporary or permanent, that has a roof over its head and the enclosed space of ground and outbuildings immediately surrounding the structure. The enclosure need not be continuous, as it may have an ungated opening for entering and exiting. Based on the law, there is no doubt the inside of the defendant's house is a structure. This is a situation where Ms. Owens is standing on the other side of the door, yelling at the defendant to come outside. There's no evidence whatsoever that Ms. Owens was trying to enter her residence. She's not jiggling the doorknob. She's not, shattering the sliding glass door or anything like that. There's no evidence that Ms. Owens said anything to indicate she was going to bust into her house. No evidence that Ms. Owens was committing a burglary of getting into her house or trying to get into her house. Also included, though, in the definition of structure includes the enclosed space of ground and outbuildings immediately surrounding that structure. That would include the defendant's porch area. The evidence has shown that Ms. Owens walked onto her porch area, the defendant's porch area, to bang on that door. So Ms. Owens did enter that portion of the structure, that porch area. But what's important about burglary is that second sentence up there in the first paragraph, or the first sentence, I'm sorry. In order for something to be a burglary, the person would have to enter the structure with the intent to commit a crime. That's why the mailman or the Amazon delivery guy can come onto the porch and drop off a package and not be charged with burglary, because there's no intent to commit a crime. Also important is the crime that is intended to be committed cannot be burglary. Obviously, you can't use the charged crime with the intended crime be the same, and it also can't be trespass. The crime has to be something other than Ms. Owens walking onto that porch by the law that we all have agreed to live by. That crime that intended to be committed to be a burglary could be theft, could be vandalism, could be some violent crime towards a person, but it cannot be simply walking onto that porch. So if you're thinking, well, Ms. Owens walked onto the porch, therefore she intended to commit a trespass, therefore it's a burglary, therefore the defendant has the right to shoot, that would be legally incorrect. And that would be a miscarriage of justice. It's legally insufficient for that to constitute a burglary. In order for the defendant to have the right to shoot Ms. Owens, there has to be it has to be done to prevent the imminent, immediate, about to happen commission of a burglary. And that burglary would have to be that Ms. Owens came on the property with the intent to commit some crime. Ms. Owens came onto the property to have the defendant come out to discuss this issue. It's not a crime to bang on somebody's door. It's not a crime to yell. There is no evidence that she came over there with any other intent but to get the defendant to come out and talk. That's why Ms. Owens' actions don't constitute a burglary. The judge also read to you an instruction that Susan Lorincz is presumed to have held a reasonable fear of imminent peril, of death or great bodily harm to herself when using defensive force that was intended or likely to cause death or great bodily harm if these two things happen. The person against whom the defensive force was used, in this case, Ms. Owens, she was the one that the force was used against, was in the process of unlawfully and forcefully entering or had unlawfully and forcibly entered a dwelling or residence, or if that person was attempting to remove another against that person's will from the dwelling. And the defendant knew or had reason to believe that the unlawful and forcible entry or the forcible act was occurring or had occurred. Notice what this instruction requires. The person was in the process of unlawfully and forcefully entering or had unlawfully and forcibly entered the residence. Not that the intruder, not that the intruder may want to come in or could come in. The intruder has to be in the process of entering the residence or in the residence. We don't have that here. As we discussed, there's no evidence whatsoever that Ms. Owens was actually in the process of unlawfully or forcibly entering the house. The defendant is not entitled to any kind of presumption that she was in fear. Based on the law that we went over and the evidence and circumstances surrounding the defendant when she chose to fire that gun, which killed Ms. Owens, her actions were not reasonable, and she was not allowed to use deadly force legally, based on the law. Now, you heard from a crime scene expert, Joshua Wright, who explained where he thought the defendant was standing when she fired the gun in the house. You heard from a computer graphics gentleman who did the video that we saw and some of the photogrammetry information that was yesterday. And those representations relied heavily on what the defendant said happened, her own version of events. You also heard from Roy Bedard, who talked in generalities about how people make decisions in stressful situations. Ladies and gentlemen, none of that testimony sheds any light on the reasonableness of the defendant's decision or the imminence of the threat that she perceived. Ladies and gentlemen, because the evidence has proven beyond any reasonable doubt that the defendant's decision to use deadly force by pulling that trigger, and because her intentional act of firing through that door caused the death of Ajike Owens, we're asking you to find the defendant guilty of manslaughter with a firearm. Thank you.
Ladies and gentlemen, we're going to take a short break, about 10 minutes, and then we'll come back and hear the defense closing argument.
Sister girl, you want to make any points on this? Or
Girl.
What y'all think? I like them too. I was just about to go through.
I want to say standing ovation, okay, to this prosecutor, okay? He did his part, so we won't say he didn't do his job. He worked for his money, so we're going to give him that. He did hit on every topic point we were talking about over the last 3 days.
Didn't he? He did.
He really did.
Now, for me, I just want to say that one of the points that I wanted him to drive home a little bit more was on those videos how she initiated everything, but he didn't mention that, which he really didn't. I believe at this point now, some of the things he didn't bring up is because he didn't have to.
Right.
Because
I agree.
That whole manslaughter versus
and I like how he used certain words, certain terms he used, like flimsy, no trespassing signs.
Yeah.
You get what I'm saying? Like letting the jurors know she didn't own that property. She bought those from a Home Depot, any store that you all can go to and purchase one and put it on your door. And we all can do that. I love how he did that. I love how he also mentioned 2 months prior to the shooting. You know what I'm saying? When he made a point to show the jurors that at that same time that Susan was the aggressor. She followed AJ. She, didn't feel like her life was in danger. I love that he was doing it. Like he really was bringing it. He spoke on facts. He kept it on facts.
Yeah, that's how I like it.
Yeah,
sure did.
Yes,
just how I like it, baby.
And when he mentioned that, even when he talked about there was being an African American woman and finding out that a white, Caucasian white woman, that would bring say a racial slur to your child. You get what I'm saying? Like it's no law against her being angry, but she didn't have a weapon. She did. Yeah, she came angry. She has the right to be angry. It's no law against banging on someone's door.
Nope.
It's no law against being upset. I love how he did that. Yeah, I got to give it to him. What's your thoughts, Paige?
He broke it down to the lowest denominator. He broke it down. I felt like he was on y'all team. He been researching
I'm
with
telling you,
y'all.
he watched the
He been
videos,
researching.
right?
Hey, I heard that Rachel. Hey, I heard that slick slur he threw in there though.
Yeah, he
Who
did.
that threw that slick slur in there
He
at
wanted
first?
to. Yup. Look, he said, "Okay, Your Honor, I know you said we can't bring that up, but look how he in his closing, he made sure to just
Look,
throw that dart out there a little bit, just a tiny smidgen.
Nothing more infuriating to a black woman. I'm like,
Yep.
okay,
me too. Yes.
I'm like, who told him?
Y'all see how he snuck that in there? Yeah, baby. Yes. Yeah.
He
Y'all
slid it in there, man.
Yeah,
he slid it in there.
Yeah, y'all want to keep it out, but okay, I'll give y'all this then. Don't forget that she said this to those kids. And this is the reason why the mama was over there upset.
Yep.
And don't forget that she threw a skate at the kid. Don't forget that she followed mom 2 months prior. Don't forget that every phone call she made to 911 was her saying that she's tired. She's tired of the kids. I love how he did that. I love it.
Job. Now, I do like that he brought up the driveway. I was so weak because we just talked about that yesterday. Karen, you wasn't scared, baby. You was provoking. You wanted all of this to happen. She set it up. I wanted him to talk more about how she set it up. He mentioned it, but he didn't need it. And another
she knew that AJ was gonna come over there.
She knew, but let me say this. One more thing. The one thing that I was like, when I first heard it, I'm like, wait. Because he brought up the weapon, and literally the 22 and the 380, the difference, if she was not trying to hurt her, and remember she said she just was hoping she would hear the shot and go away, why you didn't pick that 22? She didn't pick the 22 because it wasn't strong enough to go through that door.
That's what I was trying to say yesterday. She wanted the one that was more potent, and she knew what firearm she was going for. And I love how he mentioned that she put that back in the trash. Yeah, she know. See, he get it just the way we got it. You know what I'm saying? He knows she put that shit back in that damn.
But did you hear him say she put it back on top of the other gun?
Yeah.
So that means the other gun was already sitting in there.
Yeah, and remember, I think it was Neva said yesterday, she thinks she put it back in there, put some papers on top of it, and back in the trash can, and put papers on top of it.
So she knew what she did was wrong.
Yeah,
she knew it. When you try to cover up your tracks, you know what you doing is wrong. You know it.
She put the 22 on top like they wasn't gonna know she used the 380. Girl, if you just wanted to make some. So with that being said, that was my point. That I was like, I wish he would have talked more about her. That she really was purposely trying to kill her. But he mentioned that they didn't need to prove that. This is manslaughter, not first degree murder. You got to prove that with first degree murder, not with manslaughter. So, people don't.
I think she got manslaughter. I think she got manslaughter because she played.
Yeah, that's why I thought. That's why I thought, because I had that was me that had typed in the comments that I don't understand why it should be first degree, but I didn't know that.
No, I didn't even know you typed it because I was.
Yeah, I had put that in the chat.
I saw it.
But no, what I'm saying is that's something that I was like, dang, why he didn't say nothing about that? And then I was like, okay, that's why he didn't, you know.
But say that again.
He didn't need to prove
so
that.
I can understand. You said they only have to prove first degree. It's only first degree when it's what?
They didn't need. They did not need to prove like why she murdered her, or basically because I forgot how I said it. But he said it in this, and we can go back. We can hit on some points. I wish I was in here sitting down because I would have wrote down the timestamps when he was talking the things I wanted to talk about. But basically, he was like, you don't have to prove intent.
Okay.
Because she's not charged with first degree murder.
No, right. No, I know that, but I was asking you because you said something about the way the charge is charged. You know, the way they charge them between manslaughter and first degree, the difference. I was asking you. I was
saying that's the difference between first degree murder and a manslaughter. With manslaughter, you don't have to prove intent.
In this state, how many years does manslaughter carry? And that
30.
They said
Well,
30.
well, now that's if I seen that she was charged with first degree manslaughter. I'm not sure though, because it's different, whatever, depending on what you read. If she gets first degree of manslaughter, it carried 30 years.
Yeah.
Y'all
That's
think
the
she
only.
tried to play that old woman? I don't know what's going
Oh
on wrong.
yeah,
Of course. That's what
Y'all
she
think
was
she
telling
played
me.
that role?
Absolutely.
Y'all think she
Of
played it?
course.
Do she deserve a
Absolutely.
Grammy or Oscar?
She deserved nothing because she
She
said,
don't.
wah,
Yeah, that's why I said.
She can't
she
even
don't.
get the nominee, man. She can't even get the
Yeah,
nominee.
she didn't make the
I'm
match.
hey, get the stick. Get her up off the stage.
Yeah,
You say, girl,
what's the Sandman? There he is,
Oh man, you
Sandman.
gonna give her the Sandman? You
Yeah,
gonna
let's
bring
bring the
Sandman
Sandman
out?
out on her.
look, y'all, she even told us she bumped her head on the steering wheel.
Oh yeah.
So we gonna get back into it, y'all.
Okay.
We just wanted to
Okay.
touch on it. We
Yeah,
gonna
All
hear
right,
them.
I'm on mute.
Hey, y'all
All
gonna have to, y'all gonna be wanting to say something when these folks get to talking, but we gonna listen.
Oh no, we good. No, I'm good.
Okay, the other
Yeah, we
side.
been
I've been
sitting back
writing down my
listening.
little notes. Yeah.
Yeah, we
Look.
been sitting back listening. Let's go.
Yeah.
I'm on
Let
mute.
me tell you, the other side, man, they suck. Let's go.
Okay.
They
What
gonna
we'll
pick
do, the jurors are outside the courtroom right now. Depending how long the defense goes, if they get like,
Okay. Didn't even matter, did it? Let me hit mute. Y'all, please smack that thumbs up.
I know, right, Paige? She said, look at her victim, I'm sorry face.
Lock his ass up. Lock his ass up. You
welcome
going to
back, ladies and
jail.
gentlemen.
You
We'll
going
now
to
hear from the
jail.
sophomore. Yes, ma'am.
Good morning. This case is about perception. The Constitution of our country embodies the right to be able to defend ourselves. And there's a wisdom in our laws that begins with this concept of perception. It's central to self-defense because the law protects that reasonable perception. The law demands that we assess the reasonableness of that perception, not from the comfort of a courtroom. But we have to take ourselves back to the perspective of the moment itself. The law requires each and every one of us to look at the circumstances that Susan Lorincz was facing on June 2nd of 2023. She was almost 59 years old. She was in her home where she lived alone, a troubled neighborhood to say the least. It was nighttime. She was suffering from a multitude of medical conditions when she was startled by a barrage of screaming of profanities and banging on her door so hard that the walls were shaking in a cement block house. Now, the judge has gone over with us some of the law in this case, and it's very, very important, particularly when we are dealing with self-defense. And I know Mr. Buxman went over a little bit. I need to go over it with you, and this is the only opportunity that I have to speak with you, so just bear with me. In jury selection, the judge talked to us about this plea of not guilty and reasonable doubt. He sort of went over that instruction, and he gave it again, and there's a reason that it's one of the first instructions that we get. It's sort of the foundation of our system of justice. So what does it tell us? It tells us that Susan Lorincz has entered a plea of not guilty. This means you must presume or believe that she is innocent. So we start there. We start with the fact that she's innocent, and where does it go? Where does that presumption go? It stays with the defendant as to each material allegation in the information through each state of the trial, unless unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. That's pretty powerful language for the protection of our liberties. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. We talked about this term reasonable doubt in jury selection. I'm not going to read the whole definition to you again. The judge gave it to you again. And it's very important. And what is reasonable doubt? It means you have to be sure. Really sure. The law says you should only convict someone if you're convinced they're guilty beyond a reasonable doubt. You should feel confident in your decision without hesitation. So if there's something in the evidence that gives you pause, if you're back there and you're deliberating and you're thinking, man, she was an older woman. She had some medical issues. She did live alone. She had these prior run-ins with Ajike. I could see how she could be scared of her. And you're thinking, I did see the damage on that door. That's reasonable. I could see how she could be afraid that she was going to get through. If you're back there and you're pausing and you're hesitating, if you're wavering and vacillating, that's reasonable doubt. And if you have a reasonable doubt, you should find Ms. Lorincz not guilty, because that is what the law says. And each and every one of you took an oath to follow the law. So where do we look for reasonable doubt? It is to the evidence introduced in this trial, and to it alone. Only the evidence introduced in this trial and nothing else, that you are to look for that proof. It may arise from the evidence, the conflict in the evidence, or the lack of evidence. And if you have a reasonable doubt, you should find the defendant not guilty. Justifiable use or threatened use of deadly force. This is a very, very important jury instruction. You're going to get to work with this when you're deliberating. The laws in Florida give citizens the right to defend themselves when they are faced with imminent danger. Deadly force means force that is likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. And the most important thing in this part of the jury instruction is where it says, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. So they not only have to prove to you that she committed this manslaughter, but they also have to prove to you beyond a reasonable doubt that she was not justified in using deadly force. Now, Mr. Buxman went over this, Judge Hodges read this to us, and there's a couple important parts of this jury instruction that we need to focus on. And one is, if Susan Lorincz was in a dwelling in which she had a right to be, she had no duty to retreat. If you remember during the trial, Mr. Smith had asked some of the witnesses, did Susan shoot from way back there by her bedroom? Did she shoot from behind that countertop or behind that kitchen? It doesn't matter, because she has no duty to retreat, and she can stand her ground when she is in her dwelling if she is faced with imminent danger. Another important part of this is if she reasonably believed. We do not judge Susan Lorincz with what we in this courtroom have experienced in life. It's not what I would do, or Mr. Buxman or Mr. Smith would do in that circumstance. It's what Susan Lorincz reasonably believed was necessary to prevent. That's very important. word, prevent. The law does not say that you have to wait to get punched or attacked before you can do something. That's not what it says. You can use deadly force to prevent someone from coming into your home and hurting you or attacking you. Because members of the jury, if someone who is on the outside of your door that is banging and pounding so hard wants to get in that house and they do, it is too late. There are way too many variables if someone actually gets inside. Your gun could jam. You could get rushed. You could fall, especially if you have medical conditions. So the law accounts for that. You can do what you need to do to prevent that from happening. What was Miss Lorincz confronted with on that night when she had to make a split-second decision? We heard from Dr. Roy Bedard. He's a world-renowned use of force expert, trains law enforcement officers all over the country, and he talked to us about how someone reacts under stressful situations, these high-stakes decision-making. And he told us that when there's high consequences, you don't really know if the person on the other side of the door or the person that's confronting you is armed. Not just Susan Lorincz, but most people go to the fact that this person is armed, that they are a real threat. That's reasonable. And Susan Lorincz had no idea what Ajike Owens had on her. He told us that biologically, what happens in your brain and you're stressed, and you have these high anxiety situations, and it's releasing all of these things, your adrenal glands, and it's a high stress situation. And people have to make life or death split-second decisions when they're going through these things. He told us how a person perceives time differently. That something that was a second may have actually been a minute. And he told us that if someone's older, or if they have prior negative dealings with somebody, all of those things can affect their decision making. It's very difficult for someone to judge what is going to come next. And the law says that Susan Lorincz can defend herself to prevent the imminent commission of burglary, murder, or aggravated battery against herself. So this sort of lays out the definition of those things, and I'm not going to read it all again, but there's an important thing that I want to point out about the crime of aggravated battery. It's defined as intentionally touching or striking another with a deadly weapon, or intentionally or knowingly causing great bodily harm, permanent disability, or permanent disfigurement to another. We heard from Dr. Norford, the medical examiner in this case. And on cross-examination, she told us, yeah, I mean, if somebody is hit or kicked or punched and that person is older and they have medical conditions, that could cause great bodily harm to them. So if Ajike Owens gets through that door and just punches or kicks or hurts Susan Lorincz, that could cause her great bodily harm. We heard the statement that Susan Lorincz gave to law enforcement. We heard two of them. And Miss Lorincz told detectives on the night of that incident, Miss Owens was pounding on her front door so hard the walls were shaking. She told detectives that Miss Owens was screaming at the top of her lungs and that Susan told her, "You're trespassing, you need to leave." Susan Lorincz told detectives, "I really thought she was going to break my door down. I really thought that. I saw the door moving in, and I really believed that. I honest to God believe that." That is what she said. She reasonably believed that. We heard Susan tell the detectives, "I heard Miss Owens say, 'I'm going to fucking kill you.'" She heard that. Miss Lorincz told them, "I heard the door crack. And when I heard that door crack, I fired. We heard from Joshua Wright, the ballistics expert, and he sort of worked in conjunction with Toby Terpstra, and they created this 3D visualization that you saw. And what's important about Mr. Wright's testimony is that it's consistent with what Susan Lorincz told detectives. I was standing back near the table. There's no evidence that she moved this shell casing or did anything like that. It's consistent with what she told them. Miss Lorincz told them I wasn't going anywhere near that door. I was terrified it was going to come down. And he told us, yeah, it's pretty likely that Susan was standing by her table when she fired the gun. So how do we decide whether somebody is justified in using deadly force? And this paragraph sort of guides us in that. And it tells us that you must consider the circumstances at the time the force was used, all of it. The fact that she's in her home, she's alone, it's nighttime, her knowledge of Ajike Owens and her past interactions with her, the noise level with the pounding and the screaming of the profanities, the problems that Susan Lorincz was having physically, all of it. You have to take into account those circumstances. It's what she would reasonably do. The beauty of the law is that it does not punish individuals that reasonably perceive that danger. Now let's talk more about that danger, because the law goes one step further and it tells us that the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. And we know that it was real to her because we heard her in her statements to detectives. I really thought I heard that crack and she was coming through that door. She just believed that. And if she believes that and she perceives a danger and that danger is reasonable in her shoes, she can defend herself. She does not have to wait. So was it reasonable for Susan Lorincz to think that she was in a dangerous situation where she could be hurt or killed? This is what was standing between Susan Lorincz and Ajike Owens on June 2nd of 2023. Ajike Owens was a 35-year-old woman who was 5'7", weighed 293 pounds, and was very, very angry at Susan Lorincz. A door frame that was broken and barely hanging on. Now we heard from Charles Gabbard. He told us, you know, I tried to fix this door as best as I could. I put some screws in it, put some putty in it, and it was structurally sound. He made a point to let everybody know it was structurally sound. Not really sure how he knows that. He didn't really do any testing, but he wants everybody to know this is not my fault. As a landlord, that door was structurally sound. But it doesn't really matter whether it was or it wasn't. What matters is that Susan Lorincz knew the shape of the door and what it was like on that day. And she believed that door wasn't going to hold up. And was it reasonable for her to think that? Absolutely. All we have to do is look at the photos. The crack goes all the way down the frame. Almost all the way down. Was it reasonable for Susan Lorincz to hear a crack when Ajike Owens was banging so hard on that door? Absolutely. Miss Owens was a woman who ignored not one, see the no trespassing sign in the window, not two, but three no trespassing signs. 3. And we know this was not the first time that Ajike Owens had trespassed on Susan Lorincz's property, and we'll get to that a little bit later on. Miss Owens was very, very angry. How do we know that? What evidence tells us that? We know that there was an interaction that Susan Lorincz had with Ajike's sons, Israel and Isaac. Susan talked a little bit about it in her statements to detectives. There was an issue with a tablet and a pair of skates and an umbrella. And Miss Owens went over to confront Susan Lorincz about it. And we heard from Yaro Rodriguez, and he took the stand and he told us, Miss Owens was mad. Yaro Rodriguez told us Miss Owens' tone was a loud and a mad one. He told us Miss Owens was screaming and using words like bitch and fuck. And he told us, at first he didn't admit it. He was like, I didn't see her knock on that sliding glass door first. But we reminded him, you gave us a deposition and you told us about these things. And he said, yes, actually, I did remember. I did see that. So she went straight to this sliding glass door and she started pounding as hard as she could. And we heard from Jareth Gardner. And he told us that he was over by the basketball hoops. And when Isaac and Israel came up to him and told him something that had happened at Susan's house, and he told us one of the kids said, go get AJ. He didn't really want to tell us, but he admitted, yeah, she seemed frustrated. Miss Owens seemed frustrated. And that he heard Miss Owens knocking and then knocked again, but this time it was louder. He told us that he heard Miss Owens say, bitch, open the door. And he told us that Miss Owens' demeanor was like somebody had just messed with her kids. And he told us that even he started walking over to Susan Lorinc's home because he felt the energy and he knew an altercation was about to happen. This was not a woman that was coming over to have a nice chat with Susan Lorincz about what had happened with her children. We cannot ignore the realities of what happened that night. The state may compare this to someone just coming on to the little, come on, Susan, I want to talk to you about what happened with my kids. That is just not what happened. Miss Owens was screaming so loudly that Rosalie Smith, a neighbor that lives a football field away, heard her. She said it was so loud. So if you can imagine how loud it was for Rosalie Smith, who was a football field away, imagine what that felt like for Susan Lorincz, who was right on the other side of that door with that broken door frame. Miss Smith told us it wasn't just 3 bangs and then another 3 bangs. She told us it was a lot of pounding. I mean, a lot. And that it felt like even to her, it went on forever. Yariel Rodriguez told us Miss Owens was banging on the door hard and she was banging with her fist. I mean, he told us this is what I saw. And that she was banging in the middle of the door. And we heard from a really important witness, Yvonne Costa. The state called her as a witness, and that's Susan's neighbor that shares that wall with her. And she told us that all of a sudden, she heard a banging that was really, really bad. I mean, so bad even her walls were shaking. So bad that she was scared. So it's not just Susan Lorincz saying, man, that banging was so loud, I was scared. Her neighbor says, I was terrified. That's how hard it was. She told us that the banging stopped and then she heard it again. And then at this time it was even worse. And that there was a lot of it. A lot of banging. Not just 1, 2, 3, 1, 2, 3, a lot. She told us that while she heard the banging, she heard voices. Loud, aggressive, very guttural and deep voices, and that it sounded like it was coming from outside. Miss Owens was angry. And if she got through that door, and Susan Lorincz thought that she was going to because she saw it moving in and she heard that crack, she was in fear for her life. Ajike Owens was trespassing on Susan Lorinc's property. And Susan Lorincz was in her home where she had a right to be, and she had no duty to retreat. She had a right to stand her ground and defend herself because she was reasonably afraid. Now, the state may say, well, Susan Lorinc's fear, that wasn't reasonable because Ajike Owens never got through that door. She didn't go over to Susan Lorinc's house to harm her that night. She just merely wanted to go onto her porch and talk to her. They may say, well, did she trespass? Maybe. She never intended to harm her. But the law on self-defense accounts for situations just like this. Situations where someone unlawfully and forcefully comes onto someone else's property. The law tells us, hey, there are certain circumstances where if certain things happen, you can presume that someone has a reasonable fear. If certain things happen, you can presume that the person was going over there to cause harm. And these next two slides, they deal with that portion of the law. And we sort of have to read these in conjunction with each other. And so I want to go over the definition of dwelling. And this is something that Mr. Buxman didn't talk about. And this is really important. So dwelling means a building or conveyance of any kind, including any attached porch. Whether the building or conveyance is temporary or permanent, or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. So remember that includes any attached porch. So when we go back and we're looking at this, the person against whom the defensive force was used, aka Miss Owens, was in the process of unlawfully and forcefully entering or had unlawfully and forcefully entered a dwelling. So a dwelling includes an attached porch. So did Miss Owens unlawfully and forcefully step onto that porch? Absolutely. Not the door. We don't have to wait for her to get inside the actual house. The patio is part of the house. The law tells us that. So did she unlawfully go there? Absolutely, she was trespassing. Did she forcefully go onto the porch? Absolutely. How do we know that? Yariel Rodriguez, Jareth Gardner, Rosalie Smith, Yvonne Costa. She's yelling. She's angry. She's loud. She's banging. That's forcefully. That's what makes this different from someone like an Amazon driver coming to deliver a package. Miss Owens forcefully went on that attached porch, and that's the dwelling. And if that's the case, we have to presume that Susan Lorincz had a reasonable fear because the law tells us that we have to. If that's the case, we have to presume that Miss Owens was going over there with the intent to commit an unlawful act. We have to presume that. We don't get to guess that. Well, maybe she wasn't going over there. She was just trespassing. No, the law says if she unlawfully and forcefully entered that attached porch, we have to presume she was going over there with the intent to do harm to Susan Lorincz. This slide is really important. If you find that Susan Lorincz, who because of prior threats or difficulties with Ajike Owens had reasonable grounds to believe that she was in danger or death or great bodily harm at the hands of Ajike Owens, you may consider this fact in determining whether the actions of Susan Lorincz were those of a reasonable person. So let's talk about those prior incidents that we heard about. So Deputy Coleman testified. The state called him as a witness, and he told us, yeah, I went out there in February of 2022. And he told us, Susan Lorincz told me that Ajike Owens had battered her with a trespassing sign, hit her in the leg. And Deputy Coleman spoke to Ajike Owens. And he told us that Miss Owens told him, my dog likes to defecate on Susan's property. That's his favorite spot, and I don't care. That's where he's going to go. And unless she can show me a deed or something other than that, that's where he's going to go. Deputy Coleman talked to Miss Owens about this interaction that she had with Susan Lorincz. And Miss Owens again told the deputy, yeah, I told her I don't care about your sign. I can go get myself a sign if I want. I don't care about it. And she admitted to Deputy Coleman, yeah, I threw the sign. Deputy Coleman told Miss Owens, look, even though she's renting, that is not public space. That is private property. You cannot go over there. If you have an issue, call us. Coleman told us that he saw a red mark on Susan's leg, but despite that, he never arrested Ajike Owens. But we heard from London Remy, though, right? She was there and she saw this. She told us, I saw the sign hit Susan's leg. I mean, it barely hit her, but it hit her. For whatever reason, deputies decided not to arrest Ajike Owens. Deputy Coleman told us that Susan Lorincz had taken a photograph of Ajike Owens when they were having this confrontation. And this was entered into evidence, and it was stipulated too that this is the photo that Susan Lorincz took of Ajike Owens on February of 2022. Now, we also heard from Shelby Kinsey, and she was another deputy that had responded out in December of 2022 because of another altercation between Ajike Owens and Susan Lorincz. And Deputy Kinsey told us, I spoke to both Susan, I spoke to a mother, didn't even get her name, but spoke to a mother. We later learned it was Miss Owens, and Miss Owens told Deputy Kinsey, yeah, my 9-year-old son was mouthing off to Susan Lorincz. Miss Lorincz had told Deputy Kinsey that Miss Owens came to her house, knocked on her door, and said, if you treat my son like this again, I'm going to rip your ass out of your house and beat you up. Again, on that night, Miss Lorincz told Miss Owens, you are trespassing. Please leave my property. But Miss Owens didn't leave again on that night. She said, I have my son here. I'm just going to talk to you about what happened. Susan Lorincz said, get off of my property. And when she felt threatened, she called the police, and that's when Ajike Owens left. Deputy Kinsey told us that Miss Owens herself said, Susan told me I was trespassing. Leave. I didn't leave. I wanted to talk to her about what happened with her and my son. Deputy Kinsey told us that Miss Owens herself told her, I said to Susan, if you walk up on my sons again, you're going to have to deal with me. Those were Miss Owens' own words. Once again, Miss Owens wasn't arrested, and Deputy Kinsey told her, you can't go over there. If you have an issue, call us. In her statement, Susan had told detectives about another time that Miss Owens had followed her a couple months before this incident, where she was like a foot behind her and she was following her almost all the way into her house. And that's the reason why Susan Lorincz had all these no trespassing signs up, members of the jury. She just didn't want people on her property. Now, this slide and this part of the jury instruction sort of deals with that same premise of if there's prior interactions between Miss Lorincz and Miss Owens. And this talks about if you find at the time of the alleged manslaughter by use of a firearm, Susan Lorincz knew that Ajike Owens had committed an act or acts of violence, you may consider that fact in determining whether Susan Lorincz reasonably believed it was necessary for her to use deadly force. Now, Mr. Buxman said, well, threw the sign, hit Susan Lorincz in the leg. London Remy told us that it did, but who cares? It was a flimsy little sign, no big deal. Maybe it's not a big deal to him, but it could be a big deal to Susan Lorincz as she's experiencing a traumatic situation. And it's something you have to take into account. And she knew that she had been previously battered by this woman. It was a big deal to her, to Susan, and that's what matters. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Susan Lorincz and Ajike Owens. Why does the law do that? Because it recognizes that a 35-year-old, 293-pound woman is much more dangerous if she gets her hands on a 58-year-old woman with the physical problems that Susan Lorincz had on June 2nd of 2023. Ajike Owens has much more capabilities, and Ms. Lorinc's medical records are in evidence, and you can take your time when you're deliberating and you can go through them and look at all of those things. And we heard Susan talk about all of the medical conditions that she was suffering from when she spoke to detectives about her cervical fusion and her bad knees, and her knee going backward, and all of those things. The law says you have to take those things into consideration. I want to play this visualization for you one more time, but as you're watching it and as it transitions into the part where Susan Lorincz is in her home before she fires, I want you to focus on the door. Now, the state asked, I believe it was Mr. Smith, they asked Toby Terpstra, you took some liberties with making this video. That video was created based on Susan Lorinc's statement to detectives, where she told them multiple times, I saw that door coming in. I saw that door moving. She says that multiple times throughout her statement. That is what she said. So you can imagine how she sees this door moving the way that it is, and she knows that the door frame is damaged. How scary that must have been for her. And she had a split second to make a decision whether or not to fire her weapon. The state asked some of the witnesses about Susan Lorinc's demeanor after the fact. They did a pretty big deal about, she asked about her cats. They asked another witness, how did she seem? She's like, well, I mean, I don't know. Is it really that unreasonable for someone as a pet owner who has two cats to just say, hey, can you just close my door so that my cats don't run out? Because she asked that question, that must mean she wasn't in fear. And I want to address this. This is my only chance to speak with you, and Mr. Buxman may get up and speak, or he will get up and speak after me. So I want to address this just in case. In her interview, Susan Lorincz, they ask her questions about her researching Stand Your Ground on that second interview from June 6th of 2023. But if we go back and we remember, during that June 3rd of 2023 interview, the detective says to her, the law says it has to be imminent. And he's explaining to her sort of the law, and she's like, okay. Is it reasonable for someone to leave that interview and go and research? Man, I wonder what the law really says about this. Is that reasonable? Absolutely. The state argues that Ms. Lorincz knew that law enforcement was on the way, but we know it took law enforcement almost 15 minutes to get there. 8:54 is when she called 911. First officer didn't respond on scene until I believe it was 9:08. A lot can happen in 15 minutes, members of the jury, when you are in fear for your life. A lot. One of the last times the police came out, when Susan Lorincz told them that she had been battered, they didn't even ask Ajike Owens her name. The state says it's only 2.5 minutes. Only 2.5 minutes have went by. But Dr. Bedard, he talked to us about that perception and how that can feel like a very, very long time. And the state introduced some videos that Susan Lorincz had taken earlier in the day, and they had introduced this umbrella, and they introduced these skates. Even Mr. Buxman in his closing admitted, like, none of that even really matters. But they took the time, they introduced those things. Why do they do that? Do these skates, the umbrella, these videos, prove to you in any way that Susan Lorincz wasn't reasonably afraid? Because remember, they have the burden to prove she wasn't acting in self-defense. During the trial, Mr. Smith made it a point to ask some of the witnesses, particularly our expert, Joshua Wright, did you see there could have been gunshot residue on the door? You know, all the stuff about the gunshot residue. Did their crime scene tech ever test the door for gunshot residue? Did you ever hear any of that? It took law enforcement over 2 weeks to even go out and collect that door and place it into evidence. And by that time, Charles Gabard had already got his hands on it, sanded it down, filled it in, painted it over, before they even collected the door and placed it into evidence. A door that they made it a point to ask the witnesses, was there any dents, any scratches on it? Waited 2 weeks after Charles Gabard had done work to it to even collect it. So I want to talk to you just a little bit, and I'm almost finished, about the state's burden. And I want to show you a little bit about sort of how that means, or what that means. If you are anywhere along this chart, other than the red part at the bottom, you have to find Susan Lorincz not guilty. If you think it was self-defense beyond a reasonable doubt, she's not guilty. If you think, man, this might be self-defense, that's not guilty. Even if you think it probably wasn't self-defense, that's not enough. She's not guilty. It's not until you get down here where they've proven to you beyond a reasonable doubt that it was not self-defense. That is the only way that you can find her guilty, because the law says so. Now, this is the verdict form, and this is what you're going to see when you go back there to deliberate. And based on all of the facts and evidence, when you get back there and you're deliberating, we're going to ask you to check that box B. The defendant is not guilty. Thank you.
Mr. Buxton, can you and Ms. Sizemore approach real quick?
What y'all got? What y'all got? I don't know what they doing right now. Okay, so they mute.
First, let's start
A
with
very short break, and then Mr. Buxman will have his concluding statements to you.
Get over here.
Then we'll go from there, okay?
Okay. Go ahead.
First, let's go with it's muted. You got it muted.
Yeah.
First, let's go with the her talking about perception. So you saying you could judge me on the way you think. So you don't have, so because you don't like me on my color, the way you perceive me, that I'm a threat. You get what I'm saying?
Mm-hmm.
Because of the color of my skin or the color of my children's skin, we are a threat. So you saying that it's okay. She can go ahead, take us out, because she perceived us a threat, which her only threat was the color of that woman's skin. Well, not even AJ, because I don't even think it was about AJ. Honestly, I think it was about the kids.
It was more about the kids.
Yes. So you, because of the way you perceive my kids, like they young little nigglets, you know, they don't know no better. They just animals. That's how you perceive them. So you saying it's okay that she did this to this woman, and want to keep talking about how old she is. 59 to me, I just don't think 59 is old.
She looked 89 though.
Yeah, but they could say all that, but she's not.
Herself.
She's 59, and she didn't look like that. She was being a bully to a bunch of children. You get what I'm saying? She didn't look like that months ago. But see, that's what happens with karma. See, karma kicked down her fucking door, and that's why she's looking like that right now. That's what they need to see. That's the devil in her. See, her veil has fallen. You get what I'm saying? So we're not gonna act like because she done lost some pounds that, oh, she's such this weak old lady. No, she's not. She's not a weak old lady. She didn't look like that just 3 months ago. No, that's just, karma taking care of her. That's all that is. With that weight,
the only time she didn't look like that is when the police was there and she was powered by them. But anytime she was in court, that's
what I'm saying. Like how they got her showing in court looking all meek and timid.
That lady got on my nerves.
And all old and all. And you see how she keep looking and she lost all this weight. No, she didn't. No, go to the videos. She didn't look like that just 3 months ago. Okay? Well, 2 months ago. No, she didn't
Even
look like
old girl was speaking slow, like we supposed to feel sorry for her. That's why I speeded it up. Like, enough already. Get to it, girl. Nobody care. This ain't about sympathy. It's about the
Right.
law. The law ain't
Exactly.
about what
You
you
scared of
think.
some little black kids
None of
playing
that.
outside? Come on now.
Susan ain't good enough.
Mm-mm.
Susan is not good enough. And they still brought in the racial slur stuff too. But what did you think about her testimony overall? She was grasping to me the whole time.
Yeah, I
She
think
just
so.
needed to stay seated because everything, the stuff that she wasn't hitting on the laws. You know what I'm saying?
Oh, no facts, like the prosecutor did.
That's what. That's why I
she
like
didn't
him.
hit on no facts of what the law states with whatever they want to call.
Yeah, she went off emotion. I told you they was using the
Exactly.
sympathy. They was using the sympathy approach. How you make your client look as if they're a victim before the deliberation even began.
Right.
You see what I'm saying?
Mm-hmm.
And like I said, I had to start laughing, y'all, at that. I'm so sorry. I'm a victim. Look face she had on.
Yeah,
I
you
said,
see
look at
that?
this.
And then she
Look at this old lady. All of us going to jail. All of us going to jail. All of us going to jail.
They call all of us. Like, girl, she's sitting there with her hand. Look like an old lady sweater on.
Yeah, like she done passed out cookies in the chamber. You know what I'm saying?
Exactly.
I baked y'all some cookies. You know? Oh, lady, bro, man.
Yeah, like, lady,
late
get
now.
out of here, because let's go
Too
back to
late,
the
ma'am.
videos where she was already looking the way she was looking and being a bully. Shooing the police away.
Yeah.
No, let's stick with those videos. We're not going to talk about how she looked. I'm not saying y'all. I'm saying her defense attorney sitting up there talking about her while she's sitting there looking so broken and so defeated, like she just didn't know what to do in that moment. That this big early woman.
They worked on that look in the car. They worked
Door.
on that in the car. I'm saying they worked on that look in the car.
I had nowhere to run. I had nowhere to go. I just didn't know what to do. Girl,
Try again, ma'am. Try again.
Exactly.
So our side did really well. I like it. Now, wait a minute.
Too.
Angela, you missed a lot, but it's not over yet. So our side did really good. I'm talking about if the things we talked about yesterday, he hit on every
Angela,
point.
yes.
I'm talking about we picked it apart to the point where you're like, what about this? And what about this?
Almost like Angela, he was watching our video yesterday.
I promise. He was like, bam. Like, I love that,
Yeah, he did. He did a great job. I can't even say nothing against the prosecution in this, in their deliberation and settle, closing arguments.
Yeah, you know what? He didn't he didn't care about the animation because it was really irrelevant. They was already done. Let me tell you where they already done at. Okay, so he meant he's gonna mention the science, but I'll wait till he come back up. But actually, that's what was playing when you came in.
Okay,
so we already seen that part, y'all. Okay, you want me to play the first part so we can remember what he said and then go on, or
you could tell me.
Oh, okay. Well, I mean, it's a lot to tell. He shut her down. I think we should just play it again.
Okay, go ahead, play it.
So it'll all be in order. So you get to hear some of the things.
Now, when you say he, you mean the judge?
No, the state.
Oh, the prosecution. Okay.
Yeah. So she was trying to get jury. Yeah, she's trying to get sympathy, but she's not going by the law. She's even talking crazy. Like, for one, he already shut down the trespassing signs. He already said Charles didn't own the lot, so he had no right to tell them kids where they couldn't go. The police didn't have no right to tell them kids where they could not go. And the only place that was trespassing is if you were within her gates, which I said.
That fence.
The other thing he said, unless AJ would have had to knock down a door and be there about to shoot her. That's the only way she could have did it.
You see, I said so. The door didn't open.
Exactly. And then AJ didn't even have a weapon. She didn't even know that. She called the police. She didn't know if the police were standing there or not. But my thing, by law, the only way that woman could have got away with that is if AJ broke down that door and was standing in her living room. and that
Right.
didn't happen.
Or
So
broke that
it's-
glass on the sliding door that she said she was banging on. If that would have broken, she walked in. That's different because now you
imminent
feel in
danger.
fear.
Imminent danger is somebody literally pointing a gun at you, and you got to make a split-second decision. And she didn't have that, so she
Right.
shut down. So we gonna go ahead and play it.
Okay.
Y'all can stop it because we already listened to his second part. But you might have missed something, so we'll play. Let's go.
Okay.
I'm gonna speak.
Now, this is the verdict form, and this is what you're going to see when you go back there to deliberate. And based on all of the facts and evidence, when you get back there and you're deliberating, we're going to ask you to check that box B. The defendant is not guilty. Thank you.
Girl, don't be telling them what to select.
Russian to you. And Ms. Sizemore, approach real
She
quick.
shouldn't even be able to say that. Hold on, where's... Okay, let me move past a little bit.
A very short break, then Mr. Buxman will have his concluding statements to you. Then we'll go from there, okay?
A psychiatrist. He is not a medical doctor. He spoke in generalities. He spoke in generalities. He told you about...
I want to stop this already. Remember when we came back in and that guy, I kept on trying to find the spot where that man got sworn in and he was already sitting and then we didn't know who he was. That's who he talking about.
Yes.
He was irrelevant. Okay. I don't even know what he was there for.
Various theories. He told you about the structure in the brain and the adrenal glands and how people make decisions and what happens in a stressful situation. His testimony boils down to the more imminent and severe a threat is to someone, and the less time a person has to assess the situation and process.
Uh-oh. It's buffering.
And I just wanted to mention again, too, how her defense attorney was talking about, when she was banging on the door and she had nowhere to go. Girl, you had like 5 other rooms you could have ran into and called the police.
He gonna bring that up.
Like,
listen.
Girl, you ran into
God,
you had your bedroom, you had your computer room, you get what I'm saying? You had the bathroom. I mean, we know your little space is limited, but you had other rooms you could have ran to the back of your house and called the police. Like, oh my God, she's banging on my door. She's just crazy.
She didn't call the police back, and she went to the bathroom. She could have closed herself in there. She went to her. Yeah, he shut her down.
I just said she could have been like, hurry! How far are they? Where are they? Because she's banging outside right now.
The fact that my both of my cell phone and my computer is buffering is telling me something else is going on. I got full bars. Hold on, let me double check something. Yeah, all of my phones is doing this.
You watching this on Lord?
You gonna have pull it up because something is wrong on my end. My phones don't be doing this. Something going on.
Are you on your phone or are you on your laptop?
I'm on a laptop right now.
Okay, after 2 hours of streaming, it will lag. Sometimes you have to go out and come back in.
Yeah, she went through
I know it
yesterday.
does it on the phone, but on the laptop, I don't know about it doing on the computer. But after 2 hours, the stream get the lagging. It's not you, it's just the stream. So sometimes you got to go out.
This something
it's something else?
Yeah, this is something else. This has never happened to me.
Oh, let me see. Lord and order channel.
Let me see. Yeah, wait a minute. Let me try my other device. And then with that being said, I mean, if it's my phone, shoot, let's see if this phone.
Here we go. Okay. Let's see. How far was you in?
Okay, so wait a minute. I hear.
Okay, I got it. I'm gonna. So
wait, let me see if I can go. Yeah, it let me.
Okay, I'm just gonna sit it there in case you have this problem again.
Yeah, just sit it there. That'll be better.
Yeah, it'll be on backstage. On the back, on the back thing. Yeah, it'll just be down there in case.
Okay.
Okay.
So they on break right now.
Mm-hmm.
Let's see. Hold on, I'll be right back. Go ahead and talk, y'all.
Okay. She said, "What's that? That's why she called me." She. But
You were
yeah.
laughing at me when I said that sympathy face. Then
Oh yeah, I
you
was
were
like, yeah,
tripping,
because
wasn't
girl, you see her face? She's sitting there looking like trying to
you?
look all fucking distraught.
They
Oh,
they they
excuse
they
my
did
French,
the
but oh
zoom
my
in. They
gosh,
did the zoom, the
yeah.
slow
I'm
zoom
trying to look
in.
all
You heard
distraught
me?
and all broken and all just so weak and holding her arms like an old grandma with the grandma sweater on.
Like we gonna
No,
say, I don't think she
yeah,
did it.
no,
I
let's
don't think
take
that
us
old
back.
lady.
Take us back to the video where she was being so rude and so condescending to the police officers, and shooing them away like they were one of the dogs when she said the dog was barking, like she was shooing them like they was a daggone one of the damn animals outside. Like, no, let's keep that energy. Don't try to get up here now talking about her like she's some damn broken ass old lady. And 59 is not old.
Them kids kept going over there messing.
Yeah, they bothering me. 59 is not old. I don't even like that. She kept
I
saying
could
it as
not
if she
believe
was
she
this
was
old
59.
broken woman.
Man, that lady 72, man. They know it.
Oh, she is?
I don't know. I feel like it. Cause that
Oh
ain't no
no.
59.
Oh no. That woman is 59. She just looked like that because see, that's what karma does to you, Paige. See, when you do what the type of shit she does to people of God, girl, karma will knock down that door so quick. Look at what 2 months got her looking like. So imagine if she's found guilty, what she's gonna look like in a year.
Okay.
Imagine what she'll look like in a year.
Wow.
And even if
But you know, they
she beat it, she's still
some of
gonna
them
have
races,
karma.
you know, some races age more faster than other races.
Mm-hmm.
You know, I'm trying to keep it safe.
I know what you're saying. I
But if
get
we
you,
was
girl.
on your porch, drinking lemonade up under the
Girl,
shade,
I get you,
you know
girl.
this will be a
Yes,
uncensored kind of conversation.
I know. But listen, I know, I get it. But we know, we all get it. But that's what karma looks like. That's what karma looks like. That woman is broken looking like that because, girl, the veil has fallen off her face. So this is what she really looks like because she's nothing but the devil. She is evil.
Wow.
She set out and premeditated and planned what she was going to do to that woman. She watched those kids all day with a creepy ass and stalking those kids and starting with those kids all day. Go get your mammy, and they came over. Yup, she thought. You see how healthy and she was and good she was in that interrogation room. Well, here we are 2 months later. Look at her. Yeah, look at God. Look at God.
Look at her.
Yeah, look at her, all broken and look like she about a half a leg off of you know what. Okay, because she about to go. Yeah, bitch. Yeah, that's what happens. Like, you don't do shit like that to good people. Nobody, that woman wasn't bothering you. You was messing with her children.
Oh yeah.
You can't just do shit like that. You know, we get so fed up sometimes with all of this that go on in the world. We see it day in and day out with what happened with our color, brown skin, black and brown people.
What
you know what I'm
state
saying?
that is? That's Florida.
Yeah, that's Florida.
Wretched ass Florida. Yeah. Or is that a Confederate state?
Yeah. Mm-hmm.
It is.
Yeah.
Okay, so she tried to use privilege.
Yeah,
that's what
yes,
yeah,
absolutely. And you see how long the police, her privilege was working for her. It was working on her behalf for all them years, and the police.
That's why when they pulled up, when they pulled up, I'm like, man, we're going to jail.
Yeah.
If she
Look,
man,
had
that
she been
look
a whole
from when they
nother
pulled
color, had she been a whole nother color, we wouldn't even be on this day and going live having this conversation, okay?
Yeah, but the look is different from the first initial interview to now. The look is totally different.
Right, yeah. Look like that because see, God taking care of her now. Okay, she's reaping what she sowed. Okay,
yeah,
you know that's what she like. You know what I'm saying? That's what you
Uh-huh.
want to do. This is the life you want to live. You want to live that life. You want to hate on people. You want to bother children, innocent kids. You want to take out women, an innocent mother. These children now have no mother. And from the let the police tell it yesterday, what we watch, you know, the daddy not in their life that much either. Let
Oh,
them
they was
tell
so
it.
disrespectful with them.
Yeah, you
That
know,
was, where is
they don't
he
even
now?
know where the daddy live. You
Is he
heard
gonna come get the kids? Is he even worried about the kids?
Yeah, but you heard one of
What
the
he say
officers. Do
yesterday?
they even know where the daddy lived? That's what they said. Do they even know where the father lived?
Mm, mm, mm.
Yeah,
Mm.
because you know we don't raise our kids. We just animals, girl. No man in our
Is
house.
he in their life? Is he in their life? What the? What the?
Humans, yeah, our children are not humans, and that's how she thinks. You see
The police
the
officer turned
circle,
into a social
right?
worker.
Exactly, and the circle that she's around. Look at how the police act. This is why she felt so entitled and so privileged in doing what she did.
Is that why?
Yeah, because look at
It
what
was it a cop of color
hell,
out
they
there?
even took out a moment through her complaining while they was trying to save AJ's life, and she was complaining. You know, they took out a moment to go and adjust her handcuffs.
Are you serious?
Yes, absolutely, 100%. Okay,
Wow.
they took a moment to go and adjust her handcuffs, take them off the back, and put them to the front because she's so uncomfortable. While they were still literally working on this woman on the grass, she was complaining about her handcuffs. And they took a moment to go over there and adjust her handcuffs.
I believe this woman was so evil that she timed it. She, like I said
Yeah.
before, she knows about how long it takes for them to get there. So she called, she played like she didn't have her phone to. I mean, I'm still trying to figure out the other reasons why she wanted us to believe that it took so much longer for her to get things. That's why she's like, I washed my hands, I went to the bathroom and all of that stuff. But what I was saying is that I feel like she was trying to time it to where by the time the police got there, they wouldn't be able to save
I
AJ.
agree, Miss V. I think you may be onto something with that too. I agree, because especially when we look at the timestamps on those videos she deleted.
She been planning this for years.
Yeah, she been planning that.
I mean, yep, she been planning it ever since they got into it. And I mean, she was furious. And that woman, can't nobody convince me otherwise.
Her friends, that one friend that encouraged her to get another firearm, you know, talking to her little friends, and they got, girl, you know what you need to do? You need to go ahead and get you because that, you know what, this gonna be a problem. And if she can't control her animalistic kids, you're gonna have to handle her. I'm telling you, you know how they get in their living room, sipping their coffee and tea, drinking their coffee, sipping their tea, talking about us colored folk.
Y'all, please smack that thumbs up. We gonna get back into it. They still on, but they on, you know, they deliberating or whatever. So we gonna catch up with this.
Yeah.
Here we go,
what the chat saying, girl?
I don't know. Let us know what y'all thinking. How y'all feeling? Yeah. If anybody want to call in, let me know. I mean, I
think I saw somebody ask you that too. They asked could they call in.
Oh, really? I'll look.
Yeah,
I'll look
earlier in the chat. I think I saw that somebody asked.
Okay, I think this is the right spot when he's about to come back up.
Shout out to Neva in the chat. Shout out.
Shout out to Neva. Yeah. Shout out to all of y'all for being in the building.
And shout out to Facebook too over there watching.
Yes. I said I gotta focus in on that because either the first or I think it was the second video I did.
Angie, I remember that name. Angie Davis, Angie.
Yep. No, what I'm saying is that I'm streaming on Facebook and YouTube, and this is getting a lot of traction on Facebook. When I looked at the video last night, it had over 6,000 views.
Oh, nice.
Yeah, it's doing way better over there than over here.
Yeah,
but I mean, no,
it's doing good from Facebook too.
It's doing good over here too, though. It's doing good. So, okay, let's get into it.
Okay.
That's highly possible. Where is that in justifiable abuse of deadly harm?
It's at the end for the classy one.
For which one? Yeah.
Yeah, it's justifiable use of deadly force under when you're talking about the physical capabilities between the two.
And Deputy Kinsey responded. There was no indication of any damage done to her door. During the interview, on one occasion, there may have been
He get into it quick.
All right.
didn't he?
So I'll consider it waived.
Slow it down since he.
And we'll bring it back, and I'll try to make sure I enunciate each word more clearly.
Are we praying? What are we waiting on? Now we're not allowed.
You heard from Dr. Roy Bedard, and ask yourself, what did he add to this case? He's not a psychologist. He's not a psychiatrist. He is not a medical doctor. He spoke in generalities. He told you about various theories. He told you about the structure in the brain and the adrenal glands and how people make decisions and what happens in a stressful situation. His testimony boils down to the more imminent and severe a threat is to someone, and the less time a person has to assess the situation and process the data, the more error that creeps into the decision. I talked with him about the example, if I'm driving down the road, the person ahead of me slams on the brakes, I have to make a split-second decision. Do I slam the brakes? Do I swerve right? Do I swerve left? Or do I just brace? If I have a half second to react to that, the chances of me stopping or avoiding the threat is lower. If I have more time to evaluate and process the situation and assess my surroundings, the chance of me making a reasonable decision and a safe decision goes up. It's common sense. The threat, this perceived threat that the defendant indicated she had that day was not imminent. The threat, assuming you can even call somebody banging on a door and yelling a threat, was a threat that was coming from the opposite side of a closed, locked, deadbolted metal door. It was not immediate. It was not imminent. It was not about to happen. There was no threat. And the defendant didn't have a split second to make a decision. She had a period of time to make a decision. And she made a variety of decisions during that period of time. And that's kind of what I want to go over in this part of my closing. She told the detectives that she thought the door was going to break in. She thought Miss Owens was going to burst through the door and kill her. We know that the defendant is prone to unreasonable degrees of fear. When she was talking in her interview about the sign throwing incident, she told the detectives, and then when the first time when she threw the things at me, she was just so horrible to me. I was like, I just had neck surgery. And I'm like, she could have really killed me. And I was just like, oh, dear God, she was just violent. She is describing an incident where Miss Owens picked up a no trespassing sign, 8 by 10, with 2 little prongs that go into the ground, and tossed it at her as she was walking away. Is that reasonable to believe that that act could have reasonably killed the defendant? Of course not. And again, London Remy showed you how it happened, showed you that she tossed it. But she tells the detectives that she's like, Miss Owens could have really killed me. That tells you the reasonableness of her fear. And remember, we're looking at reasonableness through the eyes of an average, ordinary, everyday person. You heard about, and we talked about the incident, the second incident that Deputy Kinsey responded to. And Deputy Kinsey told you that she walked up and talked to the defendant. The defendant's first complaint was about the kids trespassing. And only after that does she explain or say that, oh, Miss Owens said that she was going to drag me out and whip my butt. It's interesting that she never mentions anything about that on the 911 call. She doesn't say, oh my God, I had to shoot through this door. This woman had threatened me in the past. She doesn't say that. She doesn't mention anything about that statement in either of her two interviews, despite talking to the detectives for hours. Ask yourself, how much of a role did that event play in the defendant's decision-making process to fire the gun through that locked, deadbolted metal door? Let's look more closely at the circumstances about what was going on that night and look at her own words to assess how truly afraid and how reasonable her fear was. Her first 911 call.
Yeah, the secretary's out there right now. I'm sitting for my head. I'm very scared.
It's a cell phone video from her phone taken 5 minutes before she makes the 911 call. That's what's causing her fear. That's taken moments before she calls 911. Ask yourself, is that a reasonable fear? And she's in fear for her life. That's not reasonable. So she tells the 911 operator that she is so afraid of these children. She's in fear for her life from these children. Does she run into her house, barricade her house that very moment? No. About 30 or 40 seconds before she calls 911, she's outside taking more video. But she just tells the 911 operator she was in fear of the children. Ask yourself again, is that reasonable? Her actions are completely inconsistent with somebody being in fear for her life from those children. Still the initial 911 call.
They just kept badgering me and badgering me. I'm just sick of these stupid.
Does that sound like fear of the children, or does that sound like anger?
Are you or anyone else in danger right now?
I locked my doors.
She tells the 911 operator she locks her doors, so there is no danger. Those doors were still locked. That door was still locked and deadbolted when Miss Owens comes over. Now she says she was in such fear of these children, in fear for her life, based on what she told the 911 operator. But there's a chain up there on the door as well. Does she activate that chain? She does not. She doesn't add that third level of security. Why not add that level of security if she was truly in fear for her life from these children? She doesn't do that because she wasn't afraid. She was angry. If she's in such fear of this 9-year-old child, does she take the chair that she says that she places under the doorknob and put it there for added security? No. Because again, she's not in fear of these children. She's angry. She had to walk right by that chair to go to the bathroom, like she said that she was when the pounding and things started. So we know from her interview that when this pounding and yelling began, she was in the bathroom. She hears this pounding and yelling, and she is so afraid, she goes and washes her hands. She tells you that the pounding and yelling stopped. Like it would stop if somebody is banging on the door, come out, and there's a pause for the person inside to come to the door or to react or acknowledge. Then when there is no reaction or no answer to the door, the pounding starts up again and gets louder. That is the complete opposite of somebody who is trying to get into the house. Again, there is no evidence that Ms. Owens was trying to get into the defendant's house. If she wanted to, she had every ability to do so. But she's banging, come out, pause and wait, bang again. And then the gunshot happens. If she wanted to get into the house, why not shatter the sliding glass door? Why not continually bang? Why not throw the body up against the door? None of that happened. We heard from Uriel Rodriguez, who said none of that happened. She was banging. And she was banging hard. State never tried to hide that, and I never tried to suggest otherwise. She was banging hard. As we talked earlier in my first closing, that the defendant she's not required legally to retreat because she is in her own home. So in order for her to claim and argue self-defense, she doesn't first have to retreat. But her actions inside the house are relevant to consider the degree of fear, the reasonableness of her actions, and the imminence of this perceived threat. So what do we know? When the banging and yelling starts, she's in the bathroom. This is based on her own words in her interviews. She doesn't shut and lock her bathroom door to put up another barrier between herself and this perceived threat. Instead, she leaves the confines of that additional safe space and walks towards the kitchen, towards the door. Does that sound like someone who is afraid for her life? Of course she's not, because there's a big metal locked deadbolt the door standing between her and the knocker and the yeller. In her interview, she admitted that the first words out of Miss Owens' mouth were, "Why do you speak to my children this way?" Not, "I'm going to kill you." I'm going to come into your house. Why do you speak to the children this way? When the yelling starts, she doesn't go find her phone that she had 2 minutes earlier when she just hung up the phone with 911 to call again. Instead, she goes to the bathroom to wash her hands. Ask yourself, how truly, reasonably terrified is she? The banging starts up again and she goes to her bedroom. She grabs the gun from her bedroom, and she doesn't grab the .22, the Ruger, the little plinker that she called it. She grabs the more powerful .380 Remington firearm. She doesn't shut and lock her bedroom door where she is with the gun to put up another barrier between her and this perceived threat, in case by some chance, if she truly believes that Ms. Owens is going to come into her house, now she has another barrier to protect her. She doesn't do that. She doesn't walk around the corner and point the gun ready and waiting. No, she doesn't do that. Instead, she leaves the additional safety and security and that additional barrier that she could have put up and walks towards the door. Walks towards this perceived life-threatening threat. She says she walks up to the kitchen table. She raises her firearm, points it at center of mass, where a person would be, and pulls the trigger. One shot. Not a panic flurry of gunfire, one controlled, precise shot, a kill shot.
Do y'all remember hearing this?
Ms. Sizemore.
Yes,
I don't.
did.
I don't remember.
Oh, okay. So y'all want to just listen? Okay. Let me know.
The defendant said that she heard cracking.
Oh no, I came later. I didn't hear this
listen
part.
to both interviews.
This is
and the
okay.
911 call.
We'll play it again.
You look at the transcripts. If you want to listen to them again, you have every right as a jury to listen to those interviews again. Nowhere in those interviews does she say anything such as, "I heard the door breaking, I heard the door cracking before I fired." If you want to listen to them again, you have every right to do so. There is no wood splinters on the floor. There's no new damage to the door frame. There's no wood hanging off when the deputies get there and the crime scene investigators examine it. There's no evidence whatsoever to indicate that there was a crack before the gunshot took place. You heard from Josh Wright and Toby Terpstra. They collectively created the diagram as well as the digital animation. And using the diagram created by the defense, before we do that, Catherine Medina, there was discussion about Catherine Medina doing the trajectory analysis and how that she didn't calibrate certain things. Her role was not to do a full-blown trajectory analysis. She's told you she doesn't have the training and the experience to do that. Her goal was to create a general representation of the trajectory. And even Josh Wright said, based on what she did, it may be a little larger cone of error, but her her job and what she did and her representation was a good representation of where the defendant would have been in the path of the travel of the trajectory of the bullet. But take the diagram provided by the defense as true. Who fires a gun like this? She's trained. She's gone to the range. She's practiced. She's, I think in her interview, she said she's watched videos of how to properly shoot and things like that. She even demonstrated in her interview as she held the gun like normal people hold the gun. People don't hold the gun over your head like that. That's the representation provided by the defense. That is inaccurate. That's not reasonable. People don't do that. In order for the gun to be brought down lower, she has to advance closer and closer to the door to maintain that trajectory line. Now, ultimately, does it really make much of a difference where the defendant is standing in her house when she fires? Not really. Does it matter if she's standing right by the kitchen table or if she's standing a foot or two up or a foot or two back? Not really. It doesn't change the facts in this case. What's important about where she's standing is, assuming she's even standing where she says she was standing, what's important is after she gets the gun, she's approaching the door. She's walking towards whatever this life-threatening threat that she thinks there is. She's approaching that threat. That is inconsistent with somebody who is afraid for their life. That's, unless you're a law enforcement officer, or military, or firefighter, most people don't approach the threat. They don't run towards the threat. You heard and saw the video reenactment created by Mr. Terpstra. He admitted that that was based on the defendant's version of events. The video and the way he went about creating it, it was pretty cool. It was neat. But ask yourself, what does it add to this case? It shows Miss Owens banging on the sliding glass door. Well, we know that happened. Gabriel Rodriguez told you that. It shows the defendant or Miss Owens banging on the outside of the defendant's door. Well, we know that happened too. It showed the defendant walking towards the door with her gun raised and firing a shot through the door. We know that happened. And it showed the shooting of the projectile, the bullet, through that closed door and hitting Miss Owens. We know that happened. Now, he took some artistic liberties by making the mirror shake and the door shake, and he did that on his own. He's basing it on the defendant's interview, but he decided how to make that happen and how to artistically represent that, to represent the degree of force that the defendant said she saw. That's not evidence. That's a representation of his artistic representation of what he thinks the defendant meant and what the defendant said she saw. Again, the video was cool, but it really doesn't add anything to this case. So after the shooting, we hear she makes the second 911 call. And we heard during the first couple minutes of that second 911 call, she's crying. She's upset. Of course she's crying and upset, ladies and gentlemen. She just fired a shot. She knows she shot somebody and realized the gravity and the implications of what her decision was. But notice how her demeanor changes very quickly during that 911 call when she starts talking about the children.
Something keeps trespassing over here. They're bothering me and bothering me. They won't fucking stop. Her boys were here earlier. They keep leaving their garbage all around the house. Okay. And then I told them to take the crap away. Get the fuck out of here.
That's after she fires and after the first initial minute or two of her crying. She's still angry on the 911 call. You saw Deputy Barbosa's body-worn camera when they had first made contact with the defendant. That happened right after she hung up with 911. She wasn't hysterical. She wasn't bawling her eyes out. She was calm. She was cool. She was collected. I think she asked to go in and get water and asked for something to be done with the cats. And look at her demeanor within minutes of being placed in the patrol car. She's, again, not crying. She's not hysterical. This goes to the reasonableness of her fear. Deputy Welfenberg described her demeanor as indifferent. As I said earlier, ladies and gentlemen, the law requires the threat of death or great bodily harm to be imminent before deadly force is used. There was no imminence at the time she fired that gun. The word imminent is very important. It's included in the law and the instructions for a very important reason. In order for the defendant to lawfully use deadly force, the threat to her life had to be imminent, had to be ready to happen, had to be staring her in the face, such that she had to act at that moment to protect herself. Now, some of the defendant's medical records were introduced, and there's no dispute that she has those medical records and she has some medical conditions. And if this was a situation where Miss Owens broke down the door or broke that sliding glass door and was coming at the defendant, those medical records might be relevant because her physical ability to actually engage in a fight could be relevant to this case. None of that happened. Why? Because there was a big door standing between the two of them that couldn't be breached. The defendant knows what imminent means. You heard in in one of the interviews that she did, she said, she gave an example to the detectives. She said, imminent danger is like when a 4-ton truck is coming straight at you and they are swerving with you as you try to run away. That's a very different situation than somebody banging on the outside of a secure door and yelling with no ability to enter. Ms. Owens is not a 4-ton truck. She was not coming at the defendant when the defendant fired. She was not swerving to try to get to the defendant as the defendant ran away. Ladies and gentlemen, the defendant didn't have a half second to process this. She had minutes to process this. All the decision making that we just went through in the beginning of this part of my closing, all the decisions she made, where she went, wash your hands, go here, walk around here, go to the trash can, grab a more powerful weapon, come and approach the threat and fire. And then she had the presence of mind to go back with the gun she just used to shoot and put it back in the trash can underneath the smaller 22 Ruger. Ladies and gentlemen, as a society, we do not condone shooting another person because of an This case basically requires the actions of someone who was so terrified because somebody tossed in a trespassing sign.
My bad. I did not mean to do that. But what I'm about to do, sister girl, I'm going to pull you up because I got to go do something. And I'm getting sleepy and I got to go to work tonight. Huh?
What's your point? What's your point?
You gonna get your rest?
Go to it.
Right. I have to go to work tonight, not early in the morning. So I got to go make a couple runs and
What
I don't know. I messed it up.
It's right there. What's your point you at where the prosecutor talking so I could start from there?
I know before I did that I had already messed it up, but let me I had already moved it accidentally. Let me try to find it. I'm sleepy, y'all. Hold on.
Okay.
And someone came over and had an argument with her earlier. Does that sound like something crazy, you know? I'm not going, sorry. I walked over. I said, what is your problem? And she just went on a tirade. She told you that she heard loud arguing, and then she heard a door slam. Clearly, this was the defendant slamming her door after she was arguing with the children. Go back into her bedroom, put that .380 Remington back in the trash can underneath the 22 caliber Ruger.
I don't remember, sister girl. I messed up.
It's okay.
Can you find it?
Yeah, I skipped ahead to where I think he may be. If you could just pull my thing up, I can just try to.
Okay, I'll be back, y'all. Please hit the thumbs up, everybody.
She used to shoot and put it back in the trash can underneath the smaller 22 Ruger. Ladies and gentlemen, it's a society.
Awesome. You want to remove the comments though?
Okay, no, I am. I'm kind of like
you freezing?
My thing is buffering a little bit.
So you want to refresh it maybe because you had it put up for a minute. Try refreshing it.
Well, I'm letting it refresh. It's refreshing now.
Am I good to walk away?
No, not yet. Not yet. Because right now I'm just seeing a whole black screen. I don't even see my StreamYard.
Okay. I will say you go down and come back up.
I can't do anything yet. I can't even move my
mouse.
Yeah.
So it's doing you the same way it did me. That's exactly what happened to me. You might have to power down your computer. That's what I had to do.
Yep.
That it really sucks. It's something going on though, Paige, because it never did that to me before. But at the same time, I don't usually do extremely long lives, but I have done lives like 5-6 hours before.
And it
Long
never
time ago.
done that
It
because I
never
know I
does
go
that.
live and after 2 hours,
You
no
do
matter what
like
device it
12-hour
is.
lives, don't you? Oh, for real, it do it every time.
Well, for me, it does it like if I go live and after the 2 hours, it'll start just lagging. It does it. It don't do it too much on my CPU, but it does it a lot on the phone for me. So that's where my problem come in there with it when I go do them long live.
Yeah, it definitely shouldn't be doing that, period. My guess is that, well, with all three of my devices doing that, I can't explain it. I was thinking, dang, is there something going on in the area with these providers? Let me just look it up just to see. But at the same time,
Okay, check it out.
let me see. Yeah, it's tripping for it to happen to her. Like I said, all three of my devices were circling. But what y'all thinking in the chat? What y'all thinking? Y'all got an opinion, or is everybody at work? Please smack those reactions, though. You know what I'm saying? It's very important. Even if you can't type, please hit them reactions. And if you listening, please subscribe to the channel if you have not. Thank y'all all for being here. Hold on, let me play a few things right quick while we waiting.
Lock his ass up. Lock his ass up. You're going to jail. You're going to jail. Lock his.
First and foremost, she definitely going to jail. I'm feeling good about that. I mean, they can't just blatantly overlook the law, I would hope. But hey, we gotta wait though. We still waiting, but they didn't do good at all. Please subscribe and press that notification bell and thumbs up. Please subscribe. What you think, Paige?
Like I said, the defense head came with it. Hey, this is a little old lady. She don't know what's going on, and she baked cookies for us. And they came with that approach. Then, as you had broken down more yesterday, I was really feeling it. Then I saw how she had to position the gun to shoot it, the trajectory of the bullets. I saw what co-inspired into it. I saw bits and pieces of the interview. Well, I think about it, it hurts. At the same time, you can't be happy because a mother lost her life. A child doesn't have a mother.
They back. Wait, let me see. I'm sorry. They
Okay,
doing.
go ahead.
Hold on. Let's see what they doing. Wait a minute. They must have went on another stream. Okay.
More than we can express. Jonathan Dunn's official sentence.
I see the mother.
This case basically requires you as a jury to answer one question. Was it reasonable to shoot through a closed, locked,
So 45 is about where it was
at someone who's banging and yelling on the other side? That's the ultimate question in this case.
I guess I could have did it the other way too. See, it looked like they closed that stream down. I'll just go onto the channel.
This case basically requires you as a jury to answer.
Where is the stream at? Did they go off for today? Am I missing something?
Have it done that before? When they came back, have it
Oh,
skipped
here
to
it
another
is.
one?
Yeah, they have done that before. Changed the stream. I don't know what I think they're just coming back.
They already finished recess?
Let me see what happened before this. They just coming back. Aw. Mm-mm-mm. My goodness. All right, well, we'll see what's going on. Now mine buffering. I'm so sick of this.
She got that Obama internet.
Look, for me, it's this computer. Like this, what is it? A MacBook, but it might not be strong enough for my graphics.
I don't know. MacBook, one of the best, top name, number one.
Not since I had it in my possession. I don't think laptops like me.
What type of what?
Because I love using my cell phone. BFF get on me. She used to get on me like, girl, put that phone down. Because I used to use 2 cell phones showing everything. And, little hood.
You went out and bought you a Mac.
A little rigging. Nah, my daughter, I took hers. She don't need it.
You wrong. You are wrong. Get that baby back up.
I went to visit her, and she grown. I went to visit her in Columbus and brought her MacBook back. She'll be back for it next week, but I'm gonna try to talk her into letting us keep it. Cause this is cool. This is easy streaming for me. I don't never get to pull up videos and chill like this. And I'm happy that I had the laptop at this time because this case is so important. Y'all, I got a whole playlist all the way down the 911 call. I'm talking about everything is already broken.
How much research you do on this case before you started?
I followed it from the beginning. And when I
okay, because I know you research your cases for
I do. Yeah. That's why it gotta really hit me some kind of way. Nobody ever, well, I have had, some people like BFF, couple people give me some cases they want me to talk about, but for the most part, I like to find my own by the way that it make me feel. Like I can't just cover any case. It gotta touch me in some kind of way. And I don't follow the trends either. I report what touched me. So
okay.
Come on, y'all. We back. Like, are they done? He did say in the beginning that they expected this case to not go on just until the end of the week. And they down to the day. I don't want them to decide too quick, This is an all-white jury, y'all, but the law's the law.
Man, when they said a jury of your peers, golly.
You know what, though, Paige? I believe that
not one person of color, not one.
Maybe they said they wouldn't be able to change how they feel because they seen the case already. It was some people that said that when they picked the jury. So I don't know.
They go that look. Miss T. Look. They go that
like,
look.
Girl, bye.
It is.
We don't care. Not at all. I don't feel a bit of sympathy for her, just like she don't for them. Lift your head up, Susan. You was proud when the po-po was there on your side.
I wasn't doing nothing but baking cookies. She got that baking cookies, grandma on the plantation. Look in the rocking chair.
No, she right where she need to be. Go on and get your thug on in prison. Wonder how's the noise level there, Karen.
Who picked that sweater? Who in the hell put that sweater on that lady in the car? Who did that?
You can't get
Who did
that sweater. Oh goodness. Where's sister girl? Dang, she couldn't get it back up, huh? Girl.
Her phone probably overheated.
I'm up again now, I guess. I can't leave now. This is like so important. I wasn't gonna leave. I was gonna be listening. Come on with it. What y'all got for us? It better not be no trick now.
Have a seat, everybody. All right, we're going to go back on the record on the state of Florida versus Susan Lorincz. What we're going to do is we'll bring the jurors back in. Before we take the verdict from them, I'm going to read the jurors their instructions upon discharge, which gives the jurors their rights. I hope everyone will respect that. And remind everybody to keep the same calm demeanor we've had the whole trial. Again, I appreciate it. The jurors will pass a note to the bailiff and to me. The clerk ultimately will publish the verdict. Either side wants the jurors polled. Again, we will poll them by number. Okay, and they have their numbers.
I see you, sister girl. My
Let's
bad.
bring them in. Yes, ma'am. Okay. Yeah.
I definitely wasn't looking.
Ladies and gentlemen, it's my understanding you have reached a verdict in this case. Is that correct? What I'm going to read to you is the last instruction. This regards you as jurors.
My bad, sister.
Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Can you please hand the verdict to the bailiff, please?
Oh, my heart is just dropped, Lord. They better do this right.
And have the clerk read the verdict.
Verdict as to count one. We, the jury, find as to count one of the charge. The defendant is guilty of manslaughter. Did the state prove beyond a reasonable doubt that during the commission of the offense, the defendant personally used a firearm? Yes. So say we all, dated the 16th day of August, 2024.
Does either side wish to poll the jurors to be polled?
Yes, sir.
Madam Clerk, please poll the jurors by number only.
Okay.
Juror number 1, is this your verdict? Juror number 2, is this your verdict? Yes. Juror number 3, is this your verdict? Juror number 4, is this your verdict? Yes. Juror number 5, is this your verdict? Yes. Juror number 6, is this your verdict?
Mm-hmm.
Ladies and gentlemen of the jury, if you can go back to the jury room, please wait there and I'll discharge you in a few moments, okay? Here you go. Also, here's the last one. Oh, wait, I don't think I dated that. Let me do that one back. Ms. Lawrence, the jury has found you guilty of manslaughter with a firearm. You're going to be adjudicated guilty of that offense. I assume that sentencing will be at a later date. Is that correct?
That's correct, Judge.
Are you requesting a pre-sentence investigation?
Yes, sir.
What I'm going to do is have the Department of Corrections prepare a pre-sentence investigation. I'll continue this case I'll put it all the way to
Bye-bye.
November docket, although I expect us to
We
be
want
sentenced
30
long
years.
before that.
We don't want
Just putting
nothing
it far
less.
enough away to get everything done. So when we get the PSI done, then please contact my office. We'll set a sentencing. Ms. Lorincz, you're going to be held in custody of the Marion County Jail without bond until that time. Okay.
Bye, Granny. Great,
you, and good
great
luck to you.
granny, that is. Yeah. Try again,
Well,
Susan B. Yeah, that's what I'm
We
talking
won.
about. What y'all
Look,
think? Man, the
well,
law's the freaking law.
we won the battle, but not the war yet. Let's
Yeah,
see
we
what
need
she
the
gets
time.
sent
I
in.
understand.
I want
Yes.
to see how many years she finna
Yes,
get.
let's see. We won the
Yep.
battle, but not the war.
Mhm,
Let's see how many
mhm.
years she gets.
We
We'll
want
be in
30.
recess.
We want 30. Period. What y'all think? What y'all got? Do it, man.
You see, she did. You
Yes.
call it like I see it said. No reaction from her. Yeah, because look, you
She
see,
don't
she just
care.
sat there so stoic. She didn't care. She don't care.
Sure didn't. She don't care.
So
Look
what
at
they
the
gonna?
family.
So okay. So the judge gonna.
She don't have no reaction because she already knew. She already knew. You know, the
She
lawyer
knew
tell
she
you
effed up,
before it
baby.
starts.
Right. So what they gonna come back on Monday and the judge is gonna sentence her? How does this work now? What's next?
Thank you, everybody. Have a nice day.
I didn't hear him say when is gonna be the sentencing. They have to bring her back, and maybe I missed it. Let me see what he said.
Yeah, I think I.
But they
he
have.
leaving.
I know,
The-
but he
look, the
said
judge-
something.
Oh, okay.
Like, what we gonna do next? I know it's gonna be sentencing, but how long is it gonna take and all that? So we'll just listen to it one more again.
Okay.
Let's look at it.
Have a seat, everybody.
They ain't take no time, y'all.
I
None.
knew they was guilty when they came back
All
so
right, we're going
fast.
to go back on the record on the state of Florida versus Susan
I wish they
Lawrence.
would have been in her face when
What we're
it
going
was
to
read.
do is we'll bring the jurors back in. Before we take the verdict from them, I'm going to read the jurors their instructions upon discharge, which gives the jurors their rights. I hope everyone will respect that, and remind everybody to keep the same calm demeanor we've had the whole trial. Again, I appreciate it. The jurors will pass a note to the bailiff and to me. The clerk ultimately will publish the verdict. Either side wants the jurors polled. Again, we will poll them by number. Okay, and they have their numbers. Let's bring them in.
Good try, lames.
Shit, they was probably pissing the jury off the more he was talking, trying to make it seem like she was a victim. Girl,
All three of them look defeated.
mhm.
Susan looking like I had to fight all my life.
Right.
Well, baby, you better put them dudes up. You going to prison, baby.
Exactly.
Put them up.
And everybody know who you are, bitch.
Oh, wait. What she gonna get in prison? I don't know.
You can't control no noise up in there.
Can't control nothing.
Look, they gonna be banging on pots and everything on her ass.
Yep, rattling her down.
Yeah, complain about some noise now.
Oh, I know she got to be getting it. We gonna hear something. You don't do people
How
like
you
that.
sleeping
No,
now?
it's my understanding you have reached a verdict in this case. Is that correct?
Poor AJ.
What I'm going to read to you
Right.
is the last instruction.
Deserved it.
Paradise Queen.
This regards you as jurors. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Can you please hand the verdict to the bailiff, please?
Call it like I see it at 2:57 p.m.
Okay, I'm laughing at you, girl. We sitting. I wasn't looking at none of this shit. Look.
Verdict as to count one. We, the jury, find as to count one of the charge. The defendant is guilty of manslaughter. Did the state prove beyond a reasonable doubt that during the commission of the offense, the defendant personally used a firearm? Yes. So say we all, dated the 16th day of August, 2024.
Does either side wish to poll the jurors to be polled?
Yes, sir.
Madam Clerk, please poll the jurors by number only.
Juror number one, is this your verdict?
Yeah, look at her
Juror
mom.
number two, is this your verdict?
She happy, but girl, we still
it's
ain't get justice.
bittersweet. I mean,
Yes,
she
right.
ain't got her kids. Still don't have a mom.
Yeah.
The hell,
Juror
man.
number six, is this your verdict?
Ladies and gentlemen, jury, if you can go back to the jury room.
Look, see, it's a
please
lot
wait there
more
and I'll
people
discharge
sitting
you
around her
once you know.
family now.
It actually make you more upset because it's been proven that AJ did nothing. AJ literally gave this lady grace, and when she couldn't take it no more after this woman pushed her for over a couple years.
Bully.
She bullied AJ and them.
Yeah.
That's what she did. She provoked her. She wanted it to
Jury
get
has
here.
found you guilty of manslaughter with a firearm. You're going to be adjudicated guilty of that offense.
All of them found her
Sentencing
guilty.
will be at a later date. Is that correct?
That's correct, Judge.
Are you
a
requesting
later
a
date.
pre-sentence investigation?
Yes, sir.
What I'm going to do is have the Department of Corrections prepare a pre-sentence investigation. I'll continue this case. I'll put it all the way to the November docket, although
November.
I expect us to be sentenced long before that.
Oh.
I'm just putting it far enough away to get everything done.
That's the part we missed.
So when we get the
November docket.
PSI done, then please contact my office. We'll set a sentencing.
Karen ain't going nowhere.
Lawrence, you're
She'll
going to
be
be
there.
held.
Yeah, she'll be there with the
bond.
banging fucking pots. I hope they bang pots
Thank you.
early in the
She a
morning.
flight risk, Judge. She a flight risk. Lock up.
Hey, Miss V, go back
got
a second.
pretty fast, didn't
you? That's what I want to do.
Wait a minute, Susan. Your backwards knee didn't bother you, did it? Hold on. The
Did you
backwards
see how she jumped up out that seat? Like she was pissed off.
Look.
Show that again, Miss V.
She went from feeble to Speedy
That's
Gonzalez.
true her. Yeah, that's the real her. She is angry, but she's trying to hold her composure. She is pissed that they found her guilty. She is pissed. How dare y'all find me guilty?
Look at her.
For some niggers.
Look.
Some animalistic ass kids. Y'all found me guilty. How dare y'all? Watch how she get up out that seat. Fucking raggedy ass hag. Look at her.
Ain't
Turn
nobody
around
back there
looking.
for you,
Ain't
ma'am.
nobody, right, exactly. Ain't nobody
Not
for
a damn
you, bitch.
soul.
No, nobody's here for you. Nobody came to see you, goddamn it. Shit.
Oh, LP, you miss everything. They said she got found guilty, but okay. So I seen first degree manslaughter. Now they talking about manslaughter with a firearm. What do that hold?
Watch
Probably
how she
15 years.
Have a seat, everybody. All right, we're going to go back on the record on the state of Florida versus Susan Lorincz. What we're going to do is appreciate it. The jurors will pass a note to the bailiff and to me. The clerk ultimately will publish the verdict. Either side wants the jurors polled. And we will poll them by number. Are you requesting a pre-sentence investigation?
Yes, sir.
What I'm going to do is have the Department of Corrections prepare a pre-sentence investigation. I'll continue this case. I'll put it all the way to November.
We want to see her.
What do you
moving.
mean? What do you mean? The real deadlock bae. How in the world was she found guilty? She is found guilty because she guilty. Because she, you know why she's found guilty? Do we need to say?
Oh, get out of here, troll. We don't like trolls over here. Like, beat it. Okay, I ain't never seen that
How
name
in the
in my
world was
life.
she found guilty?
That person is
Dude,
a troll.
you
Trying to
know
get
why
energy out of you.
she was found guilty? Because she's guilty.
Well,
Shit.
okay, wait a minute. Hold on, let me see something. What? Because I did not see no manslaughter with a firearm. Look.
Look.
There she go.
Oh, you slow-mo'd it. No. Do that shit the way she got up there.
Girl, I ain't gonna be able to get that better.
Oh, okay.
I probably I just
she got up and stormed out of there like, how dare y'all? You mother.
Yeah, you thought
like you guys, you see all the bleep, bleep, block, bloop, block, bleep, 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 bleep,
you
bleep,
thought
bleep.
you had it in the bag.
Yeah, she thought she had that.
Yeah,
She
so they did the right thing, but I don't know
guilty.
about this charge though.
Yeah,
I
but
feel
we
like
gonna
she should have got murdered though. I still
we
feel
gonna
like
see.
I don't know why it wasn't
what the
that.
sentencing be.
Why wasn't it considered that? Because AJ went to her house. Look, so that was her in real time. But I don't understand where they came to manslaughter at. This was premeditated. If they would have did their homework,
especially with that video after the before the 911 call.
Yeah, that's crazy to me. Like,
right.
Okay,
this was closed and shut. We all know it was closed and shut, but the way that they was trying, like the defense attorneys want to talk about perception, the way they was trying to want us to perceive it is that she was in fear of her life. Okay.
Yeah,
now,
she
AJ, was the threat. That's what they wanted us.
Beyond a reasonable doubt that she wasn't in fear at all.
Right.
And she
that is such good. That's good news.
How
so
you
today,
claim in fear
we
with no
had
deadbolt?
victory.
I mean, she deadbolt and chain. Go ahead.
We got victory today, but like I said, we won the war, but not the battle. We won the battle, but not the war.
Right.
Because
I'm gonna be irritated.
now it's gonna come. The sentencing is gonna come, and now we're gonna see. Because I saw was somebody. Okay, that was called it. How I see it. You put it up there earlier, where she said the degrees and how it's sentenced. So, do you think she's gonna be hit with the punishment of the fine, the $10,000 fine?
Well, the thing that they had put up said 15 years, $10,000 fine.
Right, that's what I was getting ready to say. Yeah, the 15
it's
years.
so many different manslaughters, but they specifically charged her with manslaughter with a firearm. I don't know what the charge for that is. The first
now that you just said
manslaughter carried 30 years is what
now that you just said that. Going back to her interrogation when she told the detectives that she didn't even have a permit to carry and all of that other stuff, can't they just add, like where I'm from, if you don't have a permit to carry, that's an extra 5 years just for having a firearm.
Where she at? I don't. I mean, it may be legal. Laws are different everywhere.
Oh, okay.
Yeah,
well, like I see it said, it's up to 30.
Then they can use their permit to carry, saying that they can switch that around and say
one though, Paige.
they can switch.
She didn't have one.
I know they'll switch it around and say she wasn't carrying it. It was in her house. They might just even say, "God dog it, give her 5 years, let her do 2, the rest on papers with a $1,500 fine."
Yup.
It's still, hey y'all, it's still some loopholes in here.
Yeah,
it's some loopholes. I'm telling you.
Like they'll find.
You gotta make the public happy. You gotta make them happy without it riding. You feel what I'm saying? They don't want it to turn into a racial war, okay?
So it's like if we got to give her a year, maybe 6 months, maybe 12 months, a year, maybe 18 months. Let's just do that to save face.
Yeah, because they're going now. They gonna come across her
And
age.
let the
Since she
city
this age right here.
pay for it. Look, and let the city pay for it.
Okay,
Because as
so
you know,
there it
it's
is, y'all.
it's only the city tax paying dollars that's gonna pay that settlement out to those children, you know.
So hold on. So I didn't. Okay, so I know that I read first degree manslaughter. So first degree manslaughter must be manslaughter with a firearm. So in Florida, manslaughter with a firearm is a first degree felony that can result in up to 30 years in prison, 30 years of probation, and a $10,000 fine.
So I don't get 30 years. You could give me up to 30 years.
Up
Yeah.
to, that right.
All
Which
right,
is,
all
which
right.
is
Oh,
why,
yeah.
Hold
hence
on,
why
y'all
the
missed something
defense,
though.
hence why the
Y'all missed
defense
something.
keep
Hold
talking
on.
about her medical condition.
Y'all missed something. 30 years probation is an option.
Yeah, no, I didn't miss that. I saw that. That's what
All
I
right,
heard.
if they give her 30
in
years
prison.
probation, if they give her 30 years probation, that means that she has to do from a week to 30 days or 60 days in the state of Florida. She would have to do that in county lockup and sound them papers.
No, okay, hold on. This is all of them together. So let me read it in full. In Florida, manslaughter with a firearm is a first degree felony that results up to 30 years in prison, 30 years of probation, and a $10,000 fine. However, a judge is required to sentence a person convicted of manslaughter with a weapon to a minimum of 10 years. 10
Well,
and a
your
quarter
5
years
years gone, Cooking Sally. Cookie,
in prison,
Miss Cooking is gone.
unless there are grounds for a downward departure.
Yeah, talking about her
They
medical
gonna use their
condition.
medical condition. That's the grounds right there.
Man, ain't
The
no
medical
grounds for
condition
that.
is the ground to get a less sentence.
Nope, it shouldn't be. You know why? Because just like Sean Grayson, he had colon cancer when he shot Sonia Massey. That did not stop him from committing that crime. Same with this
She
brother.
got a knee problem, so she
had
got a
that
medical
knee
condition.
problem.
Look,
No,
Miss
she
V,
had
but
that
he
knee
only
problem.
but he's only 30 years old. She's supposed to be so elderly. Let them tell it. She's 59.
Is a threat to the community.
Oh yeah, we know
so,
that.
Yeah, she's a threat to the
No,
community.
first
So
of all, she ain't
not
even a
find
senior
nothing.
citizen. She only 59. Shit,
Yeah,
she got
you ain't
another year to
considered-
go. She don't even qualify for AARP.
When does she turn 60?
I don't know, but she ain't no damn
I hope
senior
they
citizen.
okay.
They want to keep talking about her being old and her age and her and her medical condition. She not old. She ain't no old senior citizen because she not even 60 yet. I don't even think she's 59. She probably younger than that. They just
So she can't get that. So she can't get the 10% discount on the sentence.
No, exactly.
Okay,
She ain't getting nothing over here. That's right.
She
That
ain't
bitch
getting
gonna
nothing. That broad
that's
getting
right.
30 years. She
That's
deserves
right.
it.
She ain't even collecting the $200.
But hold on though, I am upset that because originally she has some type of abuse charges here, and I don't see that stuck, and I don't appreciate.
They didn't even talk about that much
because
in the
she
trial.
hit the kid on the toe, but I guess that was something they couldn't prove.
Yeah,
that she actually hit
they
him.
never even brought her son. So look, so
They
maybe
didn't need her
Why did she even take that
That's
out
what I
there?
was getting ready to say. That's what I was getting ready to say.
They want to traumatize him. That's why.
Yeah.
That's why
They
he
like,
didn't
we
care
don't
about
need
the
him. This is a close and
reenactment.
shut case.
He didn't care about the reenactment too either. He said that didn't even matter. It was irrelevant because once the law said that you gotta, AJ would have had to bust through the door for her to shoot her. There it is. There it is. And then she had no reason to harass the kids because that man didn't own the lot. The police wasn't supposed to say nothing. So therefore, the charge he had against AJ didn't even that should have been thrown out, and they should have said it. They should have said it. Those charges they put on AJ should have never been on her. Therefore, all the stuff is folded. Like Susan created all this stuff. I mean,
right.
Did you still want to go and finish
Angela said, I'm 58 and on disability since 2018. She was still working. This woman really is sick. Exactly.
She was working from home.
That's
from
right.
9 to 9, baby.
From
she
9
could work
to 9.
from
Look,
9 to 9.
That's full
yeah,
time.
Girl, that's
overtime and overtime and double
Said the
time.
overtime.
That's crazy.
Okay.
Wait a minute, sister girl. Hold on. Let me say this. Do you want to pull something up? Because I still got to go. Like, oh
no, we good, babe.
We good? Okay.
Yeah, we good.
Well, I guess we gonna end it then.
I may have to go in and do some
because
I had that.
I end it. They're gonna use the tax-paying citizen approach next. They finna use the tax-paying citizen approach.
What you mean by that? What is it?
I know what she mean by that, but go ahead.
You know how they just tried to use the old lady cooking cookies for the judge approach?
Man, they better not.
They gonna use the tax-paying citizen approach with the medical condition, with the age, with the she was threatened all her life. They gonna
And you know who it's gonna cost? The taxpayers. They're gonna pay that money to
I ain't never heard
family.
I've never seen kids speak at an impact statement, Emmanuel. That would be interesting. Have you ever seen children do an impact statement?
Not children.
I've never seen
not children. But
it's like it was like one of them old. I seen that in one of them old tapes. You know, when you know the family, the whole family be unalive and this one still alive. You know, I seen it in it, but that's like the early 90s, late 80s. The last time I seen a child with and his mother was there. You feel?
I get what you saying. Oh, okay. Yeah.
You know where they come up to
Back
the podium
in the day.
yeah, I seen it, but it ain't been recent, Miss T.
No, because everything changed now. You know, everything is different.
Carl said he seemed like a fair judge. He will give her more than 5. He got to give her 10. I said that too, he got to give her 10 at least.
I said that too, Cole, because at the end of the day, if anybody understands 30. What it feels like to
Sister
be
girl,
different,
let me say this right quick.
I think that judge understands.
Can you talk to the chat right quick? Because y'all still got a lot to say. I don't want y'all to just leave like that. I'm so serious. Because either, you know what I'm saying? You want to talk to the chat? They talking.
I'm here.
Okay. Go ahead, y'all. I was just looking at the messages.
Yeah, no, I was just saying, Cole, I feel you, because I said that yesterday too. That if anybody understands, the judge should understand when somebody's being judged because of the way they look. You know, that judge should understand. But I don't know. I just gotta say, Paige, I think that
she ain't got enough money to even pay for some lesser time. Judge don't care about her.
Exactly. She was living in Section 8 housing.
Man, you gotta have some money, man. You gotta have some money now. You really gotta have some money.
Trying to use her medical condition.
She gonna use her income tax check.
She using her medical condition to try to make the judge feel sympathy for her. But everybody, at the end of the day, the judge, even the prosecution and defense, they know the defense know they didn't. They know they didn't have a case. They know it was going to be really hard to save this woman because it was closed and shut.
Susan, you might just have to throw the judge a little You're gonna have to shake that thing. You're gonna have to bend over, Susan, for the judge, man. I'm telling you. Go offer him some of that wool. Go offer him some of that wool pussy, Susan. So you can get about 3 or 5, you know what I'm saying? But you ain't got that much money, you know.
But honestly, I think, I don't know. I'm still up in the air with the whole 30-year sentencing. I don't think she's gonna get 30 years. Do you think she's gonna get 30 years, Paige?
Hey, hell no.
Yeah,
no, I do not think she's gonna get 30 years because her privilege can only go so far, but just to use your privilege is a discount itself.
I agree. I don't think that she's gonna get the full 30 years. I think they're gonna find a way to downplay this and kind of she's gonna get some time, but it's gonna be like somebody said yesterday in the chat, a little slap on the wrist. She might get that 2-year, what you and Ms. B was talking about earlier. Like the least time they can give her to serve in jail and prison, they're gonna make sure that they can happen for her. That's just my opinion. because, or then again, I don't know, because they did surprise us.
Now you got to remember
in this
though.
verdict.
You got to remember. Okay, you can't get more than 30, you can't get less than 10. You have to remember the loophole in the law when it comes to sentencing. He can sentence her for 10 years. The time spent that she was in lockup, if she was ever in jail, they would suspend the sentence and put her on paper while she's still living free. That is the loophole.
Oh, I get
Okay,
what you're
that's
saying.
the loophole.
Oh, it'd be like time
like
served.
I can give you 10 years. I'm gonna suspend it 10 years, and you can do it on the street. You can do your street time, okay? Because it's more of us. It's more money to take care of you in jail than it is to let you take care of
No, and
yourself and come back and check in.
rather have our children and
Cause
grandchildren.
she using the medical condition. Now it's gonna be more of the medical condition at the sentencing. Okay, they don't want to take care of her like that. They don't. I'm telling you, they don't. They don't. I know it's a loophole. It's a loophole somewhere. She gonna go on and get judged at Wolf Puss. You know what I'm saying? They gonna make a deal.
Emmanuel said she got that ass in a circle.
That's right, Emmanuel. She gonna have to throw that motherfucker in a circle. I told them. They know. I know. Emmanuel, I know, man. I'm telling you.
Hey, she better start twerking.
She gonna be in that chamber getting chained. They're gonna be running a train in the chamber. You hear me?
I get that too. Emmanuel said the judge will also take into effect her statement and her attitude towards receiving her sentence. Yes, I think I agree there too. But I also think that the judge is going to take into accountability of her ass in the interrogation too. How she did not care. She did not care. And when she got arrested, how all she cared about was her damn cats and locking up her damn house. She didn't care about the woman that they was over there trying to save her life.
How many cats she have?
2.
Yeah, that shit was okay, but it goddamn, that little box stanky as hell. I don't care what nobody say. Fur everywhere. Fur everywhere.
Neva thinks that she's gonna get time served. They're gonna knock off the time that she did.
Time served is 50 cents.
She's gonna get time served.
Why? What do you think? Why you think she's gonna get time served?
No, that's what Neva thinks.
That's why I'm asking Neva. That's why I'm asking Neva. Yeah, I'm asking Neva why. I told y'all why I chose it. You feel what I'm saying? I told you why. You know I don't trust them mother lovers. I don't trust them. I already know. I know what you got to do, and I know what you got to do. And it's a Confederate state. It's a Confederate state too, man. Come on, man.
In the beginning, I thought she was going to get time served. But now, after hearing the verdict and all the jurors found her guilty, every one of them, she didn't have not one person on her side. Now I'm leaning more towards the sentencing and thinking that she's going to serve some time, but not a lot. They're going to find those legislation laws that can help her to, stay, just do a little teeny weeny smidgen of time and be able to come home and live her life. Because, let them tell it. She's old already,
Yeah, I told you I broke down that loophole already. I know. I see it going that way. I was just hoping they say not guilty. I hope they weren't gonna say that. Woo, Lord.
She'll get the 5 year and wind up at 8. Right, Emmanuel. That's what I'm saying. Like, I think that she'll get, they probably give it a little 5 year, but wind up doing like 18 months. Something like that. Right. That's what I'm saying. I think she'll get something like that.
Neva said she would get credit for being in. Plus, she's not doing day for day, so her time already knocked in half. That's what I'm talking about, Neva. I said the suspended sentence with the street time. That's the loophole. However many days you locked up, they gonna count the interrogation.
I don't understand those.
They're gonna count the interrogation. They're gonna count the 42-hour investigation. They're gonna count the county time. That's why I said, did she do any time? Did she get locked up that night? That's why I was asking these questions so that I can pick. I can pick all that up out.
Yeah, I don't know them Commonwealth state laws because I don't live in a Commonwealth state.
LP said definitely time served. Gonna ask for leniency for her age and condition. I know LP. That's exactly what I said. That's exactly what she gonna have to throw that ass in a circle in that chamber. You know what I'm saying, LP and Neva? Do y'all think she gonna throw that ass in a circle? Let's go. Neva, LP, Emmanuel, do you think she gonna throw that ass in a circle in the chamber? Is she gonna be chained up in the chamber?
Oh no. She said right, plus the bond. Oh, they count that too? If she was in jail during her bond?
Yeah. Yep. Because if you pay your bond, if you pay the bond, by law, you gotta come back.
She never
if
got
you
bailed
pay
out.
your bond, if you get locked up and pay your bond and get out, when your court date come back up, they're gonna give you 2 more court dates for you to get your lawyer. Because your ass had enough money to get out, then you got enough money to get a lawyer. We ain't gonna give you no PD.
Oh no, she never got out. She been serving. She been going to her trial since she been.
So there was a public defender.
No. Once they arrested her, she's been in jail since. She never got bailed out, bonded out.
And then y'all got to look at it. Is it day for day? Is it 2 for 1? Is it, is it consecutive? Is it concurrent? You got to look at that too.
I don't know what that means, child. Now you done lost me. I don't live in that no Commonwealth state. So when you say day for day, what does that mean?
You do 30 days, you do 30 days.
2
for 1 is 2 days for 1 day. 3 for 1 is 3 days for 1 day. Let's say you got 5-day sentence. You got a 3 for 1. How many days would you do if you got a 5-day sentence and it's 3 for 1? Thank you. Yeah, that's what I'm saying. That's the loopholes and stuff. You got to see what percentage it is. I sentence you 5 years at 30%. You feel what I'm saying? I sentence you 5 years at 100%.
So that's what
that means you got to do all 5 years. You can't get no time served for being in a program in there. You can't get out early. That's what they mean.
Oh, got you. So that's what, so that's what Emmanuel's saying when he's saying she's going to probably only get the little 18 months. She'll be sentenced to probably the little 3 to 5 years, but come home after 18 months.
Yeah. Now you getting it. There you go. Come on, girl. Hey, they said, she gonna. They agreed with me. They agreed.
Family, I would be livid.
Yeah, they just said she gonna be shaking ass in that chamber. They said she gonna be big booty Judy. She's definitely gonna be throwing that ass in that circle, right? And pussy popping on her handstand. Yep, that's what they said. I'm telling you, the comments they agreeing with me. They fucking with Paige. The comments is mess. Hey, I'm saying what they say.
Oh man. Oh my gosh, yo. Well, I look forward to Monday.
Yep, I'm saying what they say.
And seeing how this is gonna go down on Monday. This is November, right? The judge said he's not gonna do the sentence until November. So we have to wait all the way till November to find out how
I'll be
this
gone
is
to
gonna
November.
unfold.
I'll be gone to November.
Dang.
Yep. So they got plenty of time to do what they need to do.
Yeah, that judge gonna sit down on this. Look, sit down on it. Look, he gonna sit down on that. And
I just broke up with my ex. I'm sorry. That's my man. Just give me him. Damn, man, they done turned Susan into a bopper. Damn.
This is gonna be interesting. I look forward to November. to see how this unfolds and see what she's sentenced to.
Yeah.
But
Yeah.
I'm gonna go ahead and get going. You have
All right.
anything to say, Paige, before we close out?
Man, I appreciate y'all letting me up. Thank you so
I
much.
want to
Thank
say
you.
to you, Paige, I appreciate you coming up and giving your intake. This is why Miss V and I do this kind of stuff, like, you know, to bring the details so we can have the discussion and talk about cases like this during trials like this, you know, okay,
Yes.
controversial trials, I want to say.
You know, I've been an avid follower of Miss T for a long time, for day one. I usually be up in the bushes liking, subscribing, sharing, you know, but this about my second time up here.
Yeah,
Yeah.
this is why I like to do what I do, because I like to have the discussion and get to. I'm sorry, you guys. That's my.
It's all good. Go on, get back to motherhood, man.
Yeah,
I
no, that's
appreciate
my
it.
grandbaby. She too. She came in.
It's
Fine.
still
She running
motherhood.
around
It's
the
still
house.
motherhood.
Oh yeah, I love it, girl. I got 13 of them.
I got 3. I have 3 grandchildren. Yeah,
I
I
love
have
it,
3.
but yeah, this is why we do what we do, because
Yeah.
I like having these conversations and these discussions and bringing it to the platform and talking about it, because we see this every day. We see stuff like this every day, and at least we get that. It's refreshing to see that a jury of her peers, all white jury of her peers, I want to say, all of them agreed that she was guilty.
Oh,
That's
that was odd.
refreshing.
That was
That's
odd.
refreshing.
Because
we don't get that a
I
lot.
asked you in the comments yesterday where you from. I said her accent so thick and I like it.
Where you think
Did you
I'm
see
from?
that in the comments
No, I
yesterday?
didn't. I didn't. But where you
You
think I'm
did?
from?
That sound like Brooklyn or no,
You,
Best.
you,
I'm off, ain't it?
you hit it. You hit it. My family is originally from Manhattan, but born and raised in Brooklyn. So you hit it right on the target.
I got it right?
Yeah, you got it right. You hit it right on target. You going in and out.
Yeah, I love it though.
Yeah. I can't hear you. What you say? Oh, I think she fell. Yeah, she having some internet connections. But I want to say, guys, thank you again for hanging out with us today and watching this trial. And I look forward to November and seeing how the judge is going to sentence her. So with that said, guys, thank y'all for hanging out with us today. Stay blessed. Peace. I wish I had. This is I'm on Miss B channel, y'all know, streaming from her channel on my channel. So I can't even put up my music like a closeout to send you guys home and keep, doing the 2-step out the door. But we're gonna have to act like that pretended music. We're gonna 2-step out the door. Okay. Thank you, y'all. Hit that like button and share. Stay blessed, guys. Peace.
Yeah, I got so busy. Thank you to whoever called my business line. I am back, but I'm gonna go ahead and end it. I'm happy y'all enjoyed the show, and we'll be back in here possibly tomorrow. Thank you, Sister Girl and Paige, for holding it down. We gonna get up out of here. I'm glad I turned the music on. At least it wasn't dead silence. Please subscribe and press that notification bell and thumbs up. Please subscribe and press. Thank you for sharing me. Thank you for sharing me. Thank you for sharing me. For sharing me. For sharing me. For sharing me. Thank you. I don't know how long it's been. Oh, I just gave you a like. Thank you. I called you. Okay, good. Thank you so much for calling me. I'm on the phone, y'all. But anyway, y'all, we out of here. If y'all did not hit the thumbs up, please do. And make sure you subscribe to the channel. Peace and love, everybody. We out.
MTGBLLC.